ಮೇಡಮ್ 52 ಸೀರಿಯಲ್ ನಂಬರ್ 52 ಸೀರಿಯಲ್ ನಂಬರ್ ಏನು 12 ಗಂಟೆ ಬೇಕಾ ಬರೋಕ್ಕೆ?
ಎಲ್ಲ ಬರೇ ಇದೆ. ನಂಗೆ ಕೊಡಲ್ಲ ಅದು CPC
ಮೇಡಮ್ ಫ್ರೆಶ್ ಮೆಮೊ
ಅರ್ಜೆಂಟ್ ಇದಲ್ಲ. ಸೀರಿಯಲ್ ನಂಬರ್ 9 ಯಾರು ರಿಪೀಟ್ ಕೊಡ್ತೀನಿ ಮೇಡಮ್.
ಸರ್ ಹೇಳಿದ್ರಿ ಹೇಳಿ. ನೀವು ಅವತ್ತು ತಗೊಂಡೋಗ್ಲಿಲ್ವಾ? ಆಯ್ತು ಬಿಡಿ, ಆಯ್ತು. ಇವತ್ತೊಂದು ಡೇಟ್ ಹೋಗ್ತಿದ್ದೆ, ಮುಂದೆ ನೋಡೋಣಂತೆ. ಇವತ್ತೊಂದು ಡೇಟ್ ಹೋಗ್ತಿದ್ದೆ, ಮುಂದೆ ನೋಡೋಣ ಅಂದೆ.
ಮೇಡಮ್ ಮೇಡಮ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಕೊಡಿ ಅಂದರು. ಕೋರ್ಟ್ ಆಫ್
ಮತ್ತೆ ಅನಾವಶ್ಯಕವಾಗಿ ಕೆಲವು ಅಡ್ಮಿಷನ್ ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ಬಿಟ್ಟು ಡೆಮಾನ್ಸ್ಟ್ರೇಟ್
ಮೇಡಮ್ GMAC ನಮ್ಮೆಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಸ್ GMAC ಲಿಮಿಟೇಷನ್ ಬಾಡ್ ಟೈಮ್ MACT ಇದೆಲ್ಲ ಫೈಲ್ ಆಗೈತೆ ಆಲ್ಮೋಸ್ಟ್ 10 ಬಿಫೋರ್ ವೆಕೇಶನ್ ಆಗಿರೋದು. ಇಲ್ಲ ನಿನ್ನೆ ಮನೆ ಯಾವ ಮಾಡಿಲ್ಲ. ನಿಮಿಷ ನೋಡ್ತೀನಿ ತಡಿ. ಇಲ್ಲ ನಿನ್ನೆ ನನ್ನ ಪ್ರಕಾರ ನಿನ್ನೆ ನಾವು ಅಮ್ಮ ಆಫೀಸಿಂದ ಯಾವುದು ಮಾಡೇ ಇಲ್ಲ. ಮೇ ಬಿ ಲಾಸ್ಟ್ ವೀಕ್ ಮಾಡಿರ್ಬೇಕು. ಹಾ ಓಕೆ.
parole matter 22nd pending 22nd parole matter 22nd
ಫ್ರೆಶ್
ಜ್ಯೋತಿ ಮುಲಿ ಮೇಡಮ್
ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಅದರಲ್ಲಿ ಏನೇನು ಕಾಂಪ್ಲಿಕೇಶನ್ಸ್ ಎಲ್ಲ ಧಾರ್ಮಿಕ ಸಮಸ್ಯೆ ಅದು RC ದೇವರಾಜ್ ಬರುತ್ತೆ. ಸ್ಟ್ರೆಸ್ ಕರೀತಾರಲ್ಲ
ಅಲ್ಲಿಂದ ಒಳ್ಳೆ ಬೇರೆ ದಾರಿ ಇಲ್ಲ. ಅದೊಂದು ಆರ್ಡರ್ ತಗೊಂಡು ಆಮೇಲೆ ಹೈಕೋರ್ಟಿಗೆ
ಆಯ್ತು ಕೇಳಿ ನೀವು ಕೇಳಿ ನಾಳೆ ಸೀನಿಯಾರಿಟಿ ಏನು ಆರ್ಡರ್ ಬರಬೇಕು ಬಾರಪ್ಪ ಹೇಳಿ ಆರ್ಬಿಟ್ರೇಟರ್ ಕಾಸ್ಟ್ ತಗೊಂಡ್ತಾನೆ ಆರ್ಡರ್ ಹಿಯರಿಂಗ್ ಮಾಡಿ ಆರ್ಡರ್ ಮಾಡಿ ಪೇ ಅವರ್ ಫೀಸ್.
ಅಮ್ಮ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಪೇಜ್ ವೈಸ್ ಅಮ್ಮ ಗೌರ್ಮೆಂಟ್ ಅವರ ಸೀರಿಯಲ್ ನಂಬರ್ 21 ಕೌಂಟರ್ ಹಾಕ್ತೀರಾ ಹಾಕಲ್ವಾ? ವ್ಯಾಲಿಡಿಟಿ ಆಫ್ ದಿ ಆಕ್ಟ್
ಪೇಮೆಂಟ್ ಮಾಡಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ತೀರಾ ಅಂತ ನಾನೇ ಟೈಮ್ ಹೇಳ್ತೀನಿ ಗೌರ್ಮೆಂಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೋದು. ಸುಮ್ಮನೆ ಲೇಟ್ ಆಗುತ್ತೆ 12 ಅಮ್ಮ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ನಮೋಗೆ ಅಮ್ಮ ಏನೊಂದು ಲವ್ ಒಂದು ನೀವಾ ಓಕೆ ಆಫ್ಟರ್ 24 ಥ್ಯಾಂಕ್ ಯು. ಇದು ಚೆನ್ನಾಗಿದೆ ಸರ್, ಡೆಸಿಗ್ನೇಟೆಡ್ ಅಂತ ತಿಳ್ಕೊಂಡ್ರೆ ನಾವು ಇವ್ರು ಏನ್ ಮಾಡಿದ್ರು ನಡೆಯ ಹಾಕಲ್ಲ. ಹಂಗ ನೀವು ಮುಂದೆ ಬರ್ರಪ್ಪ, ನೀವೆಲ್ಲ ಕಿತ್ತಾಡೋದು ನಾವು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್
ನೋಡ ಇದ್ರೆ ಇರ್ಲಿಲ್ಲ ಕರೆಯೋಷ್ಟಲ್ಲಿ ಬರ್ತಾರೆ ನೋಡ.
ಅವ್ರು ಹೇಳಿದ್ರು 100% ಬರುತ್ತೆ ಅಂದ್ರೆ ಕೇಳಿ. ನಾನೇ ಹೇಳಿದೆ.
But a tender was called for the life-saving drug by the Institute of Nephrology. Just before vacation, the matter had come up, the challenge, the tender was completed.
Pending matter.
It's a new matter. Because of the paucity of time, it couldn't come up. Please.
Transfer of authorization of a fair depot on
50 days
compassionate
note.
grounds. Several matters have been disposed of, granting relief to the persons who are making the application. Kindly have it tomorrow.
ಅರ್ಥ ಕೇಳಿಸಿಲ್ಲ ಅದು.
Transfer of authorization to run fair
TDS
depot.
matter.
Yes,
ಕೊಡಿ ಬರುತ್ತೆ.
tomorrow.
Why tomorrow? It will come in regular.
Requested the matter to be listed today with a memo 2 days ago. Lordship was pleased to direct the office, but it has not come. Kindly take it up at 2:30 because
Compliance has
6
been
PM,
made.
my lord.
Compliance is, any compliance.
Compliance, only that,
If compliance is made 2:30.
2:30.
Yes. ಕೊಡಿ. ಪೆರೋಲ್ ಯಾವತ್ತಮ್ಮ? 22nd. ಡೀಟೇಲ್ಸ್ ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ. ಪೆರೋಲ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ 22nd.
One matter.
Yes. Yes, Mr. Dalwai.
That's one matter from Mandam was covered by judgment. The reason is I am an auction
Pending
purchaser.
matter, fresh matter.
Pending. I am an auction purchaser. Now, my lord, they have not issued the sale certificate. Now,
ಕೊಡಿ,
bank
ಬರುತ್ತೆ, ಕೊಡಿ.
has now issued a cancellation of mortgage.
ಕೊಡಿ,
There is
ಬರುತ್ತೆ.
some
My
date,
lord,
my lord,
senior
some date.
citizens matter, my lord. He's suffering from.
Fresh
prostate
matter,
cancer.
pending matter.
Pending matter, but I sought for, my lord, maintenance also in this case.
ಕೊಡಿ,
On
ಬರುತ್ತೆ.
22nd, lordship, may kindly put this matter, my lord.
Fresh pending. ಹಾ. ಹ್ಮ್. 21st ತಾನೆ, ನಾಳೆ ತೋಳ್. Yes. Pending regular course. Regular course. You can move 100 memos, it will come in seniority. You keep on moving, we are not stopping you from moving, it will come in seniority. Fresh or pending? Son is expired. ಮತ್ತೆ? Daughter-in-law. Nade, tomorrow. All pending matters will come in seniority. 2:30. Tomorrow you want? They'll demolish it by tomorrow. They'll come with the JCB, they'll demolish by tomorrow. ನಿಮ್ ಕೊಡ್ಬೇಕು ಅಂದ್ರೆ ಬೇಡ ಅಂತಿಲ್ಲ. Tomorrow. Pending matter will come up in regular course. All pending matter in seniority. Everybody has urgency in pending matters. We have 7,000 pending matters. All we can't take, it will come in seniority. Kodi. Sub-register will register Kata. Revenue Authority KLR, not GM. KLR gogi. Huh? In emergency for what reason? Is hospitalized tomorrow. Kodi adu. Why recalling? Told Bharat. Check ಮಾಡಿ ಅದಕ್ಕೆ. ಕಳೆದೋಗಿದೆ ಅಂತ. ಫೈಲ್ ಇಡಕ್ ಜಾಗ ಇಲ್ಲ ಅಲ್ಲಿ. ಅಲ್ಲಿ ಹೋಗಿ ನೋಡಿದ್ರೆ ನಿಮ್ಗೆ ಗೊತ್ತಾಗುತ್ತೆ. 3 rows of files. ಎಲ್ಲಿಂದ ಹುಡುಕೋದು? Medical? What medical? MTP 233. ಹಾ ಕೊಡ್ತೀವಿ. ಒಂದ್ ನಿಮಿಷ ಇದೆ, ಕರೀತಾರೆ ಇವರು. ಒಂದ್ ನಿಮಿಷ ಇದೆ.
Adjournments. Listen up.
Pending fresh matter will come in the regular course. Date ಕೊಟ್ಟಿದ್ದ. Date ಕೊಟ್ಟಿದ್ದು ಯಾಕೆ ಬಂದಿಲ್ಲ? Date ಕೊಟ್ಟಿದ್ದು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ it will have to come.
Adjournments. List number 1, page number 9, serial number 45 to 49.
40. ಏನು? Have you informed the respondent? At the request of counsel for the petitioner released on 9th July. 30 is not called out.
Page number 10, serial number 50 to 56. Page number 11, serial number 57 to 62. Page number 12, serial number 63 to 68.
My lord, serial number 65, my lord.
Yes.
My lord, I am appearing for the respondents. My lord, I have sent the objection for approval.
Have you informed the petitioner?
I have informed, my lord.
65, counsel for the respondent seeks bond is granted.
My lord, 1 week.
A week's time to file a statement of objection. Objections, if any, by 25th, relist on 30th.
Serial number 68.
Petitioner. Post before a bench of which SGRJ is not a party.
It's an interim order.
Interim order earlier granted is extended till next date.
Serial number 22 and 24, my lord.
87. Yes, ಏನಾಗಬೇಕು? ನೀವು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ. Petitioner party in person seeks bond is granted 3 weeks time finally to comply with the office objection. If office objection are not complied by 15th July, the petitioner would be liable to dismiss for non-prosecution, relist on 21st July. 15th ಒಳಗೆ ಮುಗಿಸಿ. 25 matter.
86 file the retirement, the withdrawal memo, my lords.
86 memo withdrawal reads as under, dismissed as withdrawn.
My
80. Yes. We want adjournment. Have you informed the respondent? Registry is direct, print the name of Ms. Nayantara BG as that appearing for the petitioner and delete the name of Sri Naveed Ahmed as that appearing for the petitioner. Impleading application. At the request of counsel for the petitioner, relist on 10th July.
For the respondents in this matter, my lord.
You have informed all the councils?
I appear for the respondents, my lord. Anytime next week, early next week, my lord.
IA 179, IA 1 of 26 is allowed. IA 3 of 26 is allowed. Rejoinder filed by the petitioner is taken on record. Pleadings being complete. List for final hearing on 3rd July.
My lord,
IA 2 of 26 will be considered along with the main interim order earlier granted is extended till next
My
date.
lord, there's an urgency, the matter, a shorter date may kindly be given, my lord.
Shorter date illama. Third, 2 weeks is the shortest.
my lord, see, in secondly, serial number 12, see, I pray for 10 days time. I have informed the other side, your lord.
RFA, specially ordered matter.
I- That's the reason.
At the request of council for respond number 1A to E, released on ಎಷ್ಟೊತ್ತಾಗತ್ತೆ ಇದು argument?
Third or fourth
ಎಷ್ಟೊತ್ತಾಗತ್ತೆ in argument?
argument, ಅರ್ಧ ಗಂಟೆ. ಅವ್ರು ಫಸ್ಟ್
ನಿಮ್ದು ಎಷ್ಟೊತ್ತಾಗತ್ತೆ?
ನಂದು ಒಂದು ಅರ್ಧ ಗಂಟೆ ಮೇಲಾಗುತ್ತೆ.
ಅಂದ್ರೆ ಅವ್ರು 1 ಗಂಟೆ, 1.5 ಗಂಟೆ. Released on 3rd.
Much obliged. Serial number 22 and 24, my lord, other side, my lord. Senior out of session 19/6, my lord.
22, 24 ಎಲ್ಲ ಯಾಕೆ cricket?
ರಿಪೋರ್ಟ್ R4
22 ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀರಾ?
R4 ಇದ್ರ ಸುಮಾರು ಇದು ರಿಪೋರ್ಟ್
ಬಾಲಿಗ ಇದ್ದಾರೆ, MS ದೇವರಾಜ್ ಇದ್ದಾರೆ, ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀರಾ? ಮೆನ್ಷನ್ ಮಾಡಬೇಡಿ.
serial 20
88. You have not paid the process fee. Why should we extend? Pay the process fee and come, then we'll extend.
but serial number 24, man.
Yes. ಏನಪ್ಪ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಬೇಕಾ ಏನು? ಅವ್ರು ಹಾಕಲ್ವಂತೆ. ಏನ್ ಬೇಕು ನಿಮ್ಗೆ? ಅವ್ರ ಮೇಲೆ ಹೇಳ್ಬೇಡಿ, ನೀವ್ ಹೇಳಿ. Yes, Jafar.
We have not filed your.
Validity. 21 learned AGA seeks fund is granted 2 weeks time to file a statement of objections. Objections, if any, by 2nd July, failing which will be taken as not filed, matter proceeded with, relist on 9th July.
Serial number 24, man. I am appealing for R3, my lord. Serial number 24, my lord.
24.
I am for the petitioner out of session, my lord. 19/6.
Have you informed
Inform, my lord.
council for respond number 1 and 2?
Our intimation R3 now.
Inform, ಎಲ್ಲರಿಗೂ ಇನ್ಫಾರ್ಮ್ ಮಾಡಬೇಕು.
Serial number 84.
30? ಇಬ್ರು 32 ನಾ? Who is asking for time? Ibru joint. At the request of both the councils, relist on 3rd July.
Serial number 84.
Yes.
Lord, one matter for posting tomorrow. The here Lord already notices.
One is posting ಸುಮ್ಮನೆ.
That is very urgent, my lordship.
ನೀವು ಪೋಸ್ಟಿಂಗ್ ಏನಾ? ಇವಾಗ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಇವಾಗ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೇಳ್ತಾ ಇರೋದು, ನೀವು ಪೋಸ್ಟಿಂಗ್ ಕೇಳ್ತಾ ಇಲ್ಲ. ಪೋಸ್ಟಿಂಗ್ ಯು ಆಲ್ರೆಡಿ ಮಿಸ್ ದ ಬಸ್.
Just a little late, my lord.
Serial number?
Serial number 89.
89.
To comply the office objection, grant me 1 week time.
Party in person.
Party in person.
Council, the petitioner party in person seeks fund is granted 2 weeks time to comply with the objections raised. Objection raised by registry. Objections to be complied with by 15th July, failing which the petition will be liable to be dismissed for non-prosecution, released on 21st July.
Lordship, serial number 84.1, my lord. Both sides are present, my lord. Petitioner is willing to settle the matter, my lord. It may be senior citizen, mother.
Yes.
It may be posted on 3rd of July, my lord.
Settlement ಆಗಿದೆಯಾ? Mediation.
Try to negotiate, my lord.
ನೀವೇ settlement ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ?
ಇಲ್ಲ ಮಾಡ್ಕೊಂತೀವಿ ಸ್ವಾಮಿ. Try to settle.
Trying to settle. Mediation ಗೆ ಏನಾದ್ರು ರೆಫರ್ ಮಾಡ್ಬೇಕಾ?
ಏನ್ ಬೇಡ ಸರ್.
ನೀವೇ ಮಾಡ್ತೀರಾ? Both the councils submit that the parties are in the advanced stage of negotiation for amicable settlement. They seek for and are granted 2 weeks time.
The 6th may be posted.
Released on 6th July.
Interim order.
Parties ಬರ್ಬೇಕಲ್ಲ at 2:30 PM.
Interim order in
reporting
both
settlements.
Interim order
Interim order earlier granted is extended till next date of hearing. IA 1/26 is allowed in 84.
In both the case, interim order.
Yes, Mr. Acharya.
He has consented, slight inconvenience, 12th July, he has consented, Shivkumar. 12th July, you will said 3rd July.
3rd July, well, 12th July.
Serial number 32, Miller.
32, 12th July.
I'm grateful.
Yes. 12th Sunday ante.
Sorry to trouble you not.
ನೀವೇ ಬನ್ನಿ, ನೀವೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ನಾವು ಬರಲ್ಲ. 13th ಒಳ್ಳೆ ದಿನ ಅಲ್ಲ. 13th.
In my matter, not already not government advocate is directed to take notice, but so far respondent number 4 is concerned, not is a private party, notice has to go. And there is an application that I filed for correction of cause title. Not some urgency is involved because it's
Pending matter will come in the order of seniority.
Consumer court allow the complaint. State commission dismissed the appeal. NCI, the national commission also dismissed. We have filed the execution. The opposite parties come and take the interim order in this court. Matter is very urgent, my lordship. The senior citizen.
Pending matter will come in the usual.
Last week,
course.
Matter was filed in vacation bench, Your Lordship. The caveat has come and taken time minutes. After that, matter has not come up.
Interim order has not been considered.
Not considered yet, please.
The 25th, 24th.
Could I file a memo of withdrawal, my lord, serial number 38?
Serial number 38.
Yes.
Memo of withdrawal dismissed as withdrawn.
There's one liberty, my lords,
In liberty.
to file a fresh representation to BMRC.
File a fresh representation, then file a fresh writ petition.
If needed.
You want to argue this matter, you argue, not like this.
Withdraw, my lords. I'll plainly withdraw.
Withdraw. It's made clear that there's no liberty granted as sought for.
Grateful.
Urgent petition I am filing.
Hmm.
Actually, 8th July coming the matter. I'm seeking actually on 22nd June this week.
8th July already date has been granted. Then it'll come on 8th July. It's a pending matter. Please don't move it like that.
I humbly request you.
Everybody requests. We can't accept everybody's request.
We are getting, I'm not the only person victim of the Havana syndrome technology, my lordship. More than 200 people in Bengaluru, 40 people affected with this technology, my lordship. We are getting within a second fever, headache, vomiting, nausea.
You had already filed 2 petitions. They have already been dismissed.
No,
Again, the same
no,
issue.
No, my lordship. I'm having now extra vigilance.
It'll come on 8th only. Yes.
26th 24th ಕೊಟ್ರಿ 26th ಏನ ಕೊಡಬಹುದು ಮೆಮೋ ಮೇಲೆ ಡೇಟ್
ಏನಪ್ಪ
ಕೊಡಬಹುದು ಅಂತ ಡೇಟ್ 24th ಕೊಟ್ಟಿರ್ತಾವ ಸಾಹೇಬ್
ಯಾವುದು
ಅದು ಮೆಮೋ ಕೊಟ್ಟಿದ್ದೆ 26th
24th ಬೇಡವಾ
ಬೇಡ ಸ್ವಲ್ಪ ಇನ್ಕನ್ ಯಾವತ್ತಿಲ್ಲ
ಯಾವತ್ತು ಬೇಕು
26th ಇರ್ಲಿ ಸ್ವಾಮಿ
26th ರಜಾ
27th ಇರ್ಲಿ
27th ರಜಾ
25th
30th ತಗೊಳ್ಳಿ
serial number 24 ಮೇಲೆ ಅದಸ ಇನ್ಫಾರ್ಮ್ ಮಾಡ BB Patil ಸಾಹೇಬ್
You have informed.
Yes ma'am. 19/6 ಶುಕ್ರವಾರಕ್ಕೆ
24 at the request of council for respond number 3
R3
relist on 30th June.
Interim order.
Interim order earlier granted is extended till next date.
List number 1, fresh matters, serial number 1. Shivkumar.
My lord, appear for the petitioner, my lord.
Yes.
Rare recovery.
The petitioners are the home buyers, my lord. They have purchased one flat
14.
from the
And
respondent.
AG accepts notice for respond number 2 and 3. Notice to respond number 1 is dispensed with since the respond number 1 need not be heard in the present matter. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the order passed by the KRERA in CMP 200925 stroke 0006665 as regard which recovery certificate dated 29/125 has been issued has not been implemented by the second respondent deputy commissioner. Learned AG on instruction submit that a special deputy commissioner's post has been created for implementation of the orders passed by the RERA and recovery of the amounts. His submission is that given 6 weeks time, the orders in the present petition would be implemented. His submission answers the grievance of the petitioner, reserving liberty to the petitioner to furnish the properties of the first respondent along with accompanying documents to the special deputy commissioner. The petition stands disposed in terms of the submission made by learned AG.
Much obliged.
Serial number 2, Kemparaju.
For the petitioners, my lord, has sought for a direction against respondent police, my lord, not to interfere with the operation of the petitioner's shop during night hours, my lord. Petitioner runs a tea and coffee shop in City Market, my lord. After 12 p.m., respondent police are insisting us to close the shop.
After 12 p.m., how are you running the business?
My lord, there is a latest government order, my lord, 2020.
Till what time does it permit? Daily the government order?
So that I'm not able to secure it.
You'll have to show us the government order. Till what time is it permitted? And AGA accepts notice for respond number 1 to 4. Counsel for the petition submit that there is a government order issued permitting operation of tea shops, etc. beyond 12 p.m. He seeks for and is granted a week's time to place the same on record. Released on 25th June.
Obliged.
Bharat P.
Yes, madam.
Lordship, I have filed a complaint before the Bar Council of Karnataka.
Bar Council?
Bar Council of Karnataka. I'm enrolled in Bar Council of Karnataka and I have been practicing in Bhopal, Madhya Pradesh.
Bar Council of Karnataka, Bar Council of India, Bar Council of Madhya Pradesh. Lawyer from Madhya, what is this matter?
Lordship, there are three respondent who are advocates, respondent 4 to 6, who are habitual offenders, who are habitual of filing false and malicious FIR against people who bring them under the clutches of law. These people are basically land grabbing advocates in Bhopal. And in Bhopal, your lordship. And the main culprit is respondent number 5, one Arun Srivastava, who has a team of advocates who aid them at different places, different courts at different timings to ensure that this person, Arun Srivastava, does not get under the clutches of law. In the land grabbing act that he's been doing constantly from the starting of his career since 1994. Lordship, and my client is petitioner 1. I'm party in person and petitioner 2. Your Lordship, they only have a problem with me that I am the advocate for the petitioner 1 for his father's property, share of property, and my client is a sadhu from the childhood. So his brothers, along with the advocate Arun Srivastava, respondent 5, have sold his share of land under the impression that a sadhu would.
That is also in Bhopal.
That is also in Bhopal.
So now
But
we have
they are,
jurisdiction.
Lordship, because I am enrolled in Bar Council of Karnataka, they have filed a malicious FIR and they've gone to the extent of forging the judicial records pertaining to framing of charges after.
By which court?
By Jabalpur High, trial court.
This one is in Bhopal, Jabalpur, Madhya
Lordship,
Pradesh.
but my allegations
you can't
is Madhya Pradesh Bar Council has not protected their own member who's.
Approach the Madhya Pradesh High Court, not this court.
Lordship, I see if they have not given justice, Madhya Pradesh Bar Council has not given justice to their own person who's from Bhopal, who's a local advocate, whose name was Arun, Rajkumar Pandey. They have filed 3 malicious FIR. The recent one, recently in 2026, last month, they have filed a 3rd FIR again to wreak vengeance that you cannot stop. And one of the respondents.
FIR is in Bhopal, property is in Bhopal, respondents are in Bhopal, they are registered in Bhopal.
But I am registered here, and my allegation is that the
doesn't
state.
give us jurisdiction. Please.
Lordship,
You'll have to file it in Bhopal.
I have filed a complaint here in Bar Council of Karnataka, Your Lordship, because my enrollment is here, and my allegations
What
are.
does KBCS,
They have got Bar Council of India warning already in 2020, Your
what
Lordship.
does KSB have to do with a lawyer
Because
registered
my-
in Bhopal?
Bar Council of Karnataka, my prayer is that Bar Council of Karnataka transfer my petition, my complaint to Bar Council of India, where they've already warned these 3 advocates when they have falsely invoked section 308 and 324, Your Lordship. They've invoked, and the High Court of Jabalpur has mentioned that, prima facie, the court cannot see that. Lordship may see annexure. You see how many orders are against, how many allegations against them, and the kind of orders they have is against them in
In Bhopal.
Yes, Your Lordship, what I'm telling is I would not get justice when somebody like Rajkumar Pandey, Rajshri Pandey are couple advocates. They have harassed them from 2016 and 2000 by invoking false FIR and invoking 308 and 324, and then later on.
Madam, there is no cause of action in this court, please. Third. Petitioner is before this, petitioners are before
Lordship,
this
in
court
that case,
seeking-
let me file my written arguments, Your Lordship.
written
And then Your
arguments
Lordship
you
may pass an order. I'll file my written arguments.
What written arguments and preliminary jurisdiction?
Lordship, on maintainability, I'm giving that I'm enrolled in Bar Council of
File your
Karnataka.
written arguments.
Lordship.
Counsel for the petitioner has been categorically, it's been brought to notice of the petition categorically that this court does not have jurisdiction.
Lordship, on the
Since
ground.
we are making, that's our order.
Lordship.
Since all the events have occurred in Bhopal, the allegations made against respondent number 4 to 6 are as regards events which have occurred in Bhopal. They are registered with the Madhya Pradesh Bar Council. A complaint filed before the Karnataka State Bar Council is not maintainable. The counsel for the petitioner party in petition number 2 party in person insists on filing written submission. She is granted 3 weeks time to do needful. Released on 13 July. Yes, next.
Serial number 4.
Yes, what is this?
Here, my lord, they have lien marked 1 crore 70 lakhs, which is belonging to the
From this side, you have shifted this side.
My lord,
Now you know what happens.
my lord, here the bank roll is very limited. My
And
lord, here,
Axis- Who is Axis Bank?
Francis Xavier.
Outside this one. And AGA, Andhra Pradesh and Navi Mumbai. Shri Francis Xavier is directed to accept notice for respondent number 2. Notice to respondent number 1 and 3 is deferred for now. Counsel for respondent number 2 is directed to place on record the order and information received
Lord,
by
order
respondent
I
number
have
2.
produced it at Annexure A. My lord, here, my lord, I have provided the, all the details which he has moved out, whatever the amount was deposited with the
Let us
petitioner.
find out what they have.
Please, my lord.
All the orders and information received by respondent number 2 in respect of freezing the account, stroke marking a lien on the account of the petitioner by the next date. Released on
Outstation of
22nd, it has been listed.
23rd,
22nd.
22nd outstation.
Outstation 22nd.
22nd.
Obliged.
Copy was not served to me.
I'll serve.
5. Vijay Kumar.
Madam, I
Yes.
think the respondent too, madam.
Respondent. Color filed before notice. None appears for the petitioner. Learned AGA accepts notice for respondent number 1 and 3. Shri B.N. Sanjeev accepts notice for respondent number 2. Counsel for the petitioner to furnish 2 sets of the petition along with annexures on the said counsel.
My lord, already wakalat filed, my lord. Already wakalat filed.
Petition badwa?
Already received, my lord.
Received. Released on 3rd
Similar
July.
matter covered by judgment, my lord. Similar.
He's not there.
Yes, ma'am.
Counsel for respondent submit that the above matter is covered by the decision in so and so to provide an opportunity to petitioner to make a submission. Released on 3rd July.
Serial number 6. Yes, Mahadev.
Owner of a single screen theatre. Earlier, the sanitary charges was 72. In 2013, it was enhanced to 10,000, including the single screen theatre as a multiplex category. That was challenged by.
Want your representation to be considered.
Yeah, the representation ಕೊಟ್ಟಿದ್ದೀವಿ. Meanwhile, they have offered one-time settlement ಕೇಳಿದ್ದಾರೆ. ಅದ್ರಲ್ಲಿ ನಮ್ದೇನ್ ಕಂಟೆನ್ಷನ್
ಬರೀ representation will direct
ಅಲ್ಲ
them to
ನಾವು ಕೊಟ್ಟಿರೋದನ್ನ ಡಿಡಕ್ಟ್ ಮಾಡಿ ಅಂತ ಅವ್ರೇನ್ ಹೇಳೋದು ಅಂತಂದ್ರೆ ವಿ ವಿಲ್ ಅಡ್ಜಸ್ಟ್ ಇಟ್ ಟುವರ್ಡ್ಸ್ ಇಸ್ ನಾಟ್ ಲೋನ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್.
ನೀವು ಕೇಳಿರೋದು only to consider your.
ಸರಿ ಅದು.
We'll direct them to consider. ಅಷ್ಟೇ ಮಾಡಕ್ಕಾಗದು ನಾವು. KB Monish Kumar for respondent number 1 and 2. Petitioner is before this court seeking for the following leaves. The grievance of the petitioner is that the representation submitted by the petitioner on 26/24 and 3/9/24 at annexure E and F have not been considered by the respondent. So also the reply issued by the petitioner on 25/26 at annexure J has not been considered. Whenever any representation submitted by a citizen to a statutory authority like the BWSSB it is required for the statutory authority to consider the same and pass necessary orders within a reasonable period of time, either accepting or rejecting the request made. In the present case, the request having been made in the year 2024 has continued to remain pending, which cannot be said to be reasonable. Hence, I pass the following order. Writ petition allowed, direct to consider the representation dated so and so at Annex E and F.
Meanwhile, let
within
them
a
not
period of
disconnect.
4 weeks from the date of receipt for a copy of this order. ಅದೆಲ್ಲಿ ಕೇಳಿದ್ದೀರಾ?
ಅಲ್ಲಿ ಕೇಳಿ ಎಂಟ್ರಿ ಮಾಡ್ರು ಅಂತ ಕೇಳಿದೀನಿ. ಯಾಕಂತಂದ್ರೆ ಅವಾಗ
within a period of 30 days from the date of
ಹೌದು.
receipt of a copy of this order. Until then, the respondents are restrained from disconnecting the water and sanitary connection to the petitioner.
7, Puneet Kumar.
Yes.
For petitioner, Your Lordship, challenging the order passed by the respondent number 2, which is at annexure Q, Your Lordship, page number 179. District registrar has been passed misinterpreting partnership deed as a joint development agreement, Your Lordship. The petitioner has
DGA
filed.
accepts notice for respondent number 1 and 2. Issue notice to respondent number 3 and 4. Returnable by 20th July. Where is the document?
Lordship, annexure Q, page number 179.
That is the order. Where is the document?
Lordship.
Where is the document which is as regards which Article 5F has been invoked?
Annexure D, Your Lordship.
Page?
Annexure, yes.
103.
103.
Partnership deed, which is at page number 97. 97, Your Lordship.
There's a reconstitution, cancellation of the partition.
We have entered a partnership deed, Your Lordship. Thereafter, I have completed the construction of cafe restaurant. I was looking after the business, Your Lordship. Thereafter, after 6 months, some misappropriation was done between me and the landowner, Your Lordship. Thereafter, we entered the dissolution deed, which is at annexure D1, Your Lordship. Page
The
number 1.
dissolution deed, the property has been transferred.
Not transferred, Your Lordship. The landowner is respondent number 3 itself. We have entered partnership deed. Thereafter, I have.
The property is bought into the partnership. The property becomes a joint, the partnership property.
Be valued.
If at the time of dissolution, the property goes to somebody, it is a transfer.
It was not transferred to the partnership firm's name, Your Lordship. It was standing in the name
as capital.
Yes, Your Lordship.
Capital and it becomes the property of the partnership firm.
No, Your Lordship. It was standing in his name itself. Thereafter, I have invested and I have developed so and so. I was looking after the business, Your Lordship.
That property has been brought in as a capital to the firm. It becomes the property of the firm.
Yes, Your Lordship.
On a file your objection.
But Article
On
40
reconstitution,
says,
in
Your
this case,
Lordship,
my lord, what
if
has
it is
happened
of a reconstitution of partnership firm, it is not reconstitution, Your Lordship. No further amendment was carried out. No further partnership deed was amended, Your Lordship. Your Lordship may look at Article 40 of Karnataka.
What is 103?
Dissolution deed, Your Lordship.
What is dissolution?
Dissolution, I am taking my sort of thing. I am going out of the partnership
It
firm.
is also a kind of reconstitution. If under dissolution something happens, partnership ceases to exist, reconstitution, partnership continues with reconstituted partners.
But in the order passed by the respondent number 2, Your Lordship, he has considered it as a joint development agreement. If any interest transfer between the parties, if I have developed any portion of as a flat or plot, Your Lordship, I have not given share to the landowner or any third party, Your Lordship.
Who is getting the property now?
Respondent number 3. Earlier, it was standing in his name.
Now there are some developments.
Constructed area, who is getting?
This landowner, Your Lordship.
Constructed.
In partnership deed, the share allotted to the partners was also discussed, Your Lordship, and the development charges are made as my investment, Your Lordship. Your Lordship may see at page number 98, Your Lordship. If it is for reconstitution of partnership.
Objections, your Geda.
I'll file my objection.
AGA accepts 1 and 2. Issue notice to respond number 3 and 4. Returnable by 14th July. I1 of 26 not pressing. I1 of 26 stands dismissed as not pressed.
Serial number 8, R. Kotwal.
Forest.
Appearing for the petitioners, my lords. My lord, this is a case filed for seeking direction to quash forest development tax collected by the respondent, my lords. Kindly take page number 20, my lords.
Yes, madam, same order.
Please.
And AG access notice for
Appeal is
respondent.
pending.
My lords,
Appeal is pending.
my lords, we have sought an interim relief also, my lords.
We are disposing of the matter as per the.
There is a subsequent auction conducting on 1911, my lords. On that auction, you have said the FDP may not be imposed on the petitioners, my lord. That's all.
Same order as in page 23.
Serial number 9. Subramania Iyer.
For the petitioner, my lords, kindly issue a notice to the respondents, my lords. There is an interim prayer, my lords.
Issue a show cause notice.
Show cause
Why
notice.
are you carrying a show cause notice?
Because there is a illegal transaction happened in the
Show cause notice,
Kannada
you have to
Sahitya
go
Parishad.
reply there, not challenge.
ಇಲ್ಲ
show cause.
ಆದ್ರೆ ನಾವು ಅಪಾಯಿಂಟ್ ಆಗಿದ್ದು ಮೈ ಲಾರ್ಡ್ಸ್ ಅದಕ್ಕೆ ಮುಂಚೆ ಅದಕ್ಕೆ ಆ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಆದ್ಮೇಲೆನೆ ನಾವು ಅಪಾಯಿಂಟ್ ಆಗಿರೋದು ಮೈ ಲಾರ್ಡ್ಸ್.
ಆಯ್ತು, ಅದು ಹೋಗಿ ರಿಪ್ಲೈ ಮಾಡಿ.
ಅದಲ್ಲ ಅದು ನಮ್ದು
Order
ಅದಕ್ಕೆ
which has
ನಮ್ಗೆ ಏನು
been
ಸಂಬಂಧ ಇಲ್ಲ. ಅದ್ರ ರೆಸ್ಪಾನ್ಸ್ ಇದು ಅದ್ರ ಲಯಬಿಲಿಟೀಸ್ ಎಲ್ಲ ನಮ್ಮ ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ ಮೈ
ನಾವು
ಲಾರ್ಡ್ಸ್.
ಫ್ಯಾಕ್ಚುಲಿ ನಾವು ಡಿಸೈಡ್ ಮಾಡಕ್ ಆಗಲ್ಲ. You go and reply to it and pass orders on that. Whatever you want to say, you can say there. A show cause notice.
Kindly have a short date, my lords. My senior will come and convince.
ಸುಮ್ಮನೆ ಲಿಸ್ಟ್ ಮಾಡಿ ಅಜ್ಜನಕ್ಕಲ್ಲ. Lord AG accepts notice for respondent number 1 and 2. Petitioner is before this court seeking for the following leaves. What is essentially challenged is a show cause notice dated
Annexure E.
6/5/26 at Annexure E. The petitioner would always have the liberty to reply to the said show cause notice, placing the say of the petitioner on record before the respondents. And it is for the respondents to consider the same and pass necessary orders. In that view of the matter, the above petition stands disposed, granting liberty to the petitioner to reply to the said show cause notice within 15 days from today, that is on or before 30th of June 2026. Once the reply is received by the respondent to consider the same and pass necessary orders within 30 days of the receipt of the said reply. Needless to say, until orders are passed on the said reply, the respondents cannot take any coercive steps against the petitioner.
Serial number 10. Kiran SS.
For petitioner.
AG accepts notice for respondent
Parole.
22nd.
Parole.
Parole.
11.
Much obliged.
Kiran ಬಂದ್ರೆ ಬರೀ parole.
My lord. No new matters, my lord. I'll stop.
You do this, but do other things.
Yes, my lord. I will
ಇದು
take.
ಮಾಡಬೇಡಿ ಅಂತ ಹೇಳಿಲ್ಲ ನಾವು. ಬೇರೇನು ಮಾಡಿ, ಬರೀ parole ಮಾಡಬೇಡಿ.
Yes, my lord. Much obliged.
11.
Transfer of authorization on compassionate ground. Rejected on the ground, my father is aged about 68 years. And similar matter was covered by judgment of this
ಎಲ್ಲಿ
honorable
madam?
court. Next,
ಏನ್ ಪಾಲಿಸಿ ಏನಾಯ್ತು? Hereditary office.
I have asked them to formulate some policy, my lord. But my lord, there are catene of judgments regarding age, my lord. But here is a case where income, my lord. They have stated they have 3.1 acres of land also, my lord.
That is
Income
not
is
there.
also a issue here, my
That
lord.
is not there in your criteria.
rules ಅಲ್ಲಿ ಏನಿಲ್ಲ.
ಏನು ಇಲ್ಲ. You have to formulate a proper policy.
That I have informed, my lord. I have spoken to the secretary, my lord.
ಇವಾಗ ಇದ್ರಲ್ಲಿ ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದು? When did your father get it?
Father died on.
Died ಅಲ್ಲ. When did he get the authorization?
Authorization was in the year 2020. Kindly see the page number
First
14.
authorization 2020 ನೇನಾ?
Page 14, 11/12/2020.
And
For a
AG
period of
accepts
5
notice
years.
for respondent 1 to 4. Petitioner is before this court seeking for the following. The petitioner claims that the petitioner's father had been granted authorization bearing number 10 of 2020-21 for running a fair price shop at Kannamedi village, Pavagada Taluk, Tumkur district. Unfortunately, this said father expired on 4/12/25, leaving behind the petitioner as his only legal heir. The petitioner made an application for transfer of the authorization on compassionate basis, which came to be rejected by a respondent on the ground that the father of the petitioner was aged more than 60 years, and as such, the transfer could not be made. This court in a catena of decisions has held that the age of the authorization holder is not relevant for the purpose of consideration of the transfer. It is the age of the transferee which is relevant. In the present case, the age of the transferee stroke
60.
applicant is 30 years as on today. In that view of the matter, the embargo under the rules do not adversely affect the petitioner's claim. As such, I pass following order. Writ petition is allowed. Endorsement at Annexure D is squashed. Mandamus is issued directing response to consider the application of the petitioner and pass necessary orders in terms of the above observation within a period of 4 weeks from the date of receipt of a copy of this order.
Rejected on 2 grounds, my lord.
Yeah, ಇನ್ನೊಂದು
Yeah, 24, page 24, my lord. ತಹಸೀಲ್ದಾರ್ ಅವರ ವರದಿ ಮತ್ತು ನೀವು ಸಲ್ಲಿಸಿರುವ ದಾಖಲೆಗಳ ಅನ್ವಯ ಮೃತರ ಕುಟುಂಬಕ್ಕೆ 3.11 ಜಮೀನು.
ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್ ಇದೆ 3 ಎಕರೆ 11 ಗುಂಟೆ ಅಂತ.
The second reason for rejection of the application is on the ground that the family of the petitioner owns 3.11 acres of land which is used for agriculture purposes, and as such they have a source of alternate income, and as such the transfer cannot be made on compassionate basis. The second reason which has been provided by response for rejection of the petitioner is not provided for in the rules pertaining to transfer, in as much as there is no restriction for transfer on compassionate basis on the ground that the transferee has sufficient alternate income or otherwise. Hence, this ground is not sustainable.
Serial number 12, B.S. Jeevan Kumar.
Serial number 12 and 14 are same, my lords.
12 and 14.
12 and 14, my lords.
Yes.
My lords, petitioners were respondents before the arbitrator. My lords, when the matter was set down for the defendants, respondents evidence, my lords, I filed 2 applications, one for production of documents and one for amendment. My lords, that said 2 applications have been dismissed on a common order, my lords. If my lords were to kindly take page number 23, my lords.
You cannot challenge this.
Lords,
These are not orders which can be challenged.
under section
In writ
37.
petition, only in 34 you will have to raise.
Plus, not in 37, Manoj. 37, I have no remedy, Manoj. Only in the writ petition I have a remedy. 34, there should be a final order. Manoj, my entire right.
Writ petition is not maintainable for any stage in the arbitration.
Section 37, I have a right to challenge an interim orders, Manoj, which are passed, which are enumerated as per section 37.
Section 16 under 9.
Please, that's, Manoj, it is an application. If my, Manoj, if production of documents have not been allowed, my entire right for contesting.
You can
and I
only
have
challenge it under 34.
And I have taken that claim in the statement of objection because when a statement of objections were filed, part work was completed. There's still work going on. Final bills were not raised and final bills will be produced at a subsequent event.
It will be a good ground for you in section 34. Not now.
Entire right, Mallards of the
Supreme Court is very clear on it. We can't.
I'll verify my request for Monday, Mallards.
ಏನ್ ಮಾಡ್ತೀರಾ ಜೀವನ ಏನು ಇಲ್ಲ
ಇನ್ನೊಂದು ಅವಕಾಶ
ಸುಮ್ನೆ ಅನ್ನೆಸರಿ ಬೇಡ ಏನಾರು ಇದ್ರೆ ಕೊಡ್ತಾ ಇದ್ವಿ ಇಟ್ಸ್ ಅನ್ನೆಸರಿ
12 and 14 both.
Petitioner is before this court seeking for the following leaves. Arbitral proceedings were initiated by the respondent and an arbitrator having been appointed, the arbitration.
Because it was referred from MSME Council under section 18.
The MSME Council alwala, the arbitrator is functioning under the Arbitration Center, Karnataka.
It has not been referred under section 9. It was referred from MSME Council under section 18.
On a dispute being raised, on a dispute being raised by the respondent, the MSME Council referred the matter to arbitration, which is taken up under the aegis of the Arbitration Center, Karnataka, Domestic and International, Bengaluru. In the said proceedings, when the matter was set down for trial, the petitioner filed two applications in IA-2 and 3. IA-2 being under section 19(2) and section 23(2) and 23(3) of the Arbitration and Cancellation Act 1996 to produce certain documents. the ಇದರಲ್ಲಿ ಯಾವ ಚಾಲೆಂಜ್ ಮಾಡಿದೀರಾ?
ಇದು ಫಸ್ಟ್ ಅಲ್ಲಿ
IA2.
IA2.
The said application came to be rejected by a common order on IA2 and 3 dated 29th April 26 in AC number 622 of 2023. It is challenging the said order that the petitioner is before this court. Arbitration, in a Catena judgment, the Honorable Apex Court has categorically held that courts should not normally interfere in the arbitral proceedings, and the proceedings have to go on in terms of the provisions under the Arbitration Cancellation Act 1996. The limited interference is in terms of Section 37 of the Arbitration Cancellation Act, which is reproduced hereunder for easy reference. A perusal of the aforesaid extracted Section 37 would indicate that it is only orders which are passed under Section 9 and allowing Section
8,
16
Section 9.
that an appeal could be filed. There is no provision under Section 37 for challenging an order under Section 19 bracket 2, Section 23 bracket 2 or Section 23 bracket 3, disallowing an application to produce documents.
And
The
for-
disallowing could be a ground which could be raised by the petitioner in an application filed by the petitioner under Section 34 in the event of the award being passed against the petitioner. Reserving such liberty, no grounds being made out, petition stands dismissed. ಅದರಲ್ಲಿ 14 ನಲ್ಲಿ application IA3 under Section 23 bracket 3 of the Arbitration Cancellation Act 1996 with a request to carry out amendments in the statement of objection and counterclaim, which came to be rejected.
13. Chinmayi Chandra.
13.
My lords.
Yes, madam.
This is the regulatory dispute where the
TDSAT is
petitioner.
not working, is what
TDSAT is not working. I'm before your lordships because I operate in the Mangalore region. I am a multi-system operator providing network distribution of cable TV networks. The respondent is a broadcaster, Discovery Communication, which gives signals to Discovery Channel, Animal Planet, Cartoon Network. My grievance is that on 19th of May,
They are based in Delhi.
they are based in Delhi. But
how do you
I'm
file it
based
here?
in Mangalore region. My subscribers who are stand to be affected and the interconnection regulations are really for the protection of the subscribers. That is in Mangalore and that is why I've come before this honorable court. If I may just show to your lordships the
You're asking for reconnection. They've already disconnected.
they've already disconnected without providing any notice whatsoever. Please see the letter of 6th of March 2026. This is at page 107. All they wanted was audit reports for the last 5 years. Under the interconnection regulations, I am supposed to give them the audit report for the last 1 year. For last year, the audit report or audit was done in 2025. I have provided the audit report to them. If I may just, my lords has page 107. You may skip to 108, the very second last paragraph. In light of the above, we request you to kindly share with us the audit reports for the years 2021, 2022, 23, 24, and 25 of your subscriber management systems.
You
Their
were a-
entire grievance,
You were a licensee from 2021?
even prior to that, I've been a licensee
Asking
since.
during the period of your license.
But they cannot. Please see now the interconnection regulations, regulation 15 with respect to audit. This is at page 176. I get audited every year. If at any point in time they had a grievance with respect to my audit,
What is the problem in providing the audit report
I have provided it to them.
from 21?
I have provided it for last year,
What is the
for
problem in providing 21?
25. If your lordship directs me, I will do so. But
They're only
the
asking for
disconnection,
that.
please see the disconnection of signals without any notice of disconnection whatsoever. They are mandated to one
Ask you for
provide.
documents, you don't provide.
That's no ground for disconnection of signals. Please see
Don't provide.
regulation 15.
Issue notice to the respondent, return of emergent notice.
Your
written
lordships,
out
I am
by-
before your lords only for a
We
period
cannot
of
direct
2 weeks.
reconnection as an interim prayer.
May I just show your lordships orders passed by the TDSAT and by the Delhi High Court?
It is virtually allowing your petition.
Please appreciate, my lords. I am here only for till the TDSAT reopens on the 1st of July.
Yes.
The only reason I am before your
Yes, which order do
lordships,
you want us to see?
if your lordships may see at page 1,
Hmm. This is after
These-
notice.
no, admit, the respondent accepts notice and para 5.
Hmm.
Till further orders, the network of the petitioner shall not, I'm sorry, your lordships are at page 1.
Hmm.
We direct that the supply of signals to the petitioner's network may be continued.
Yeah, continued.
Thereafter, page 5, the next order.
Yes.
Because all of these are cases where as soon as a notice of disconnection is issued, the petitioner has a right to go to the tribunal. Here they have disconnected without any notice.
We can injunct a person from disconnecting.
I'll show
Can
your
we
lordship.
ex parte direct somebody to reconnect?
I'll show your lordships.
Show us a judgment on that.
Please see at page 9.
9. Yes.
Admit Saurabh Srivastava accepts notice. This is on day 1. This petition, the third paragraph, this petition is filed against the disconnection notice. In pursuance of the notice, the respondent has disconnected the supply of its signals to the petitioner on 5/6/2015. I am worse off because without a notice of disconnection, they have disconnected it. Then towards the end, on hearing the counsel of the parties, we direct the respondent to restore the supply of its signals to the petitioner in the course of the day, provided the petitioner makes an on-account payment of 15 lakhs.
Yes.
Please see the urgency. It's in the course of the day. That's because when signals are disconnected without providing any notice, it's the subscribers who suffer. Before 3 weeks before disconnecting signals, there must be a public notice that's to be issued. This is provided for in the regulations. All parties are bound by the
This
regulation.
order also, if you don't make the payment, it automatically stand disconnected.
Yes, there is no.
There is a situation
see.
that you are asked to give certain documents. You are not given the
I have
documents.
provided the documents
You say
today.
you
They
are
have
not
called
required
upon.
to provide documents.
They
You
have
took
called
the risk
upon
of-
me today for conciliation. If I may just show, your lordship saw their letter of 6th of March. Please see my reply at page 109.
Yes.
We are surprised to receive a request seeking audit reports for the last 5 years. Neither the current interconnection agreement, that's the agreement between me and the respondent, nor the telecommunications regulations of 2017, which is the interconnection regulations which are binding, contemplate sharing of audit reports going back 5 years on a belated request. And the fact that such a request is being made at this stage demonstrates that Discovery Communications is seeking to achieve some oblique underhanded motive against the undersigned. We are constrained to bring on record serious concerns in the matter. You are aware that parties had signed an interconnection agreement somewhere in the middle. DCI is obligated to provide on a non-discriminatory basis the signals of its television channels it distributes, and that imposition of any term or condition which is unreasonable is deemed by law to constitute a denial and derogation of the interconnection regulations. Thereafter, your lordships may skip to para 4. DCI has been
Refused to give it.
And thereafter for
Making so
2020,
many allegations.
for
And you
2020,
still want to continue business with them.
for
You're making so many
2020,
allegations.
because please see
Issue
regulation
emergent notice
15.
to the respondent, counsel for the petitioner is
Your
going to
lordships
take
may-
out
this
and
is-
summons on the respondent. When will you serve the and summons?
Tomorrow itself.
Relist on 19th.
Your lordships, I'll have to go back to the TDSAT on the first. Please, the signals have been disconnected since 19th of May.
Madam, we don't
Please just
appreciate
see-
your client's stand. Not about you, but about your client's stand. in
Please,
Not giving the
One
documents
last
requested and
regulation.
giving all these, look at the kind of letter that they've addressed.
Please see, one last regulation. If just a minute.
You serve it on them, 19th will take it.
Just one minute's indulgence, my
Yes.
lords. I'm sorry for pushing for your lordships, but just at page 176, audit, every distributor shall get addressable systems of its distribution platform, such as the subscriber management system, conditional access system, digital rights management systems, etc. For the preceding year, audited by an auditor to verify the information contained in the monthly subscription reports made available by the distributor to the broadcaster. And the distributor shall ensure that the relevant audit report, including all annexures, is shared with each broadcaster with whom it has entered into an interconnection agreement by the 30th of September every year. For last year, the audit was done in December 2025. I have provided it.
Have you provided from 21?
Your Lordships, I'll have to get instructions on that, but we have raised
Not
bills.
provided and you
We
don't
have
want to
raised bills,
provide.
they have raised bills, we have paid the amount. Otherwise, why would they continue with an interconnection agreement with me? Thereafter, provided
19th.
that the authority,
19th,
they have no right of disconnection, my lords.
madam.
An earlier date,
19th, what you want?
Very well.
Today is what?
I'm grateful. 17th, I'm grateful.
Yes. You serve it, if you serve it and they come, we'll take it.
May I get the order today itself?
Hopefully. Next.
I'm grateful.
Yes, Srinivas.
All the subvention matters where the
Subvention. Who is the developer?
my lord, develop ozone, my lord. It was connected with the yesterday's matters wherein the interim order has been granted.
Sumana Baliga, sorry, yaru?
Sukanya Bali.
Sukanya Baliga. For respond number 1, yaar,
Pradeep Shaw.
Minister of Finance, you appear.
SDF.
Bhimayana. Ministry of Finance. Case Bhimaya for respond number 2. Pradeep Saukar for 3. National Housing Bank.
Sukanya Bali.
Sukan.
Case Bhimaya for 1 and 2. Pradeep Saukar for 3. Sukanya Baliga for 4. Velankani Ravi for respond number 5. SDF's
Francis Xavier.
Francis Xavier. PL Vandana for respond number 7 and 8. Same order. Connect with so and so.
Protection,
Yes.
which is granted, my lord. It may be extended till next day.
Yes. 16 also same?
16 and 17, all three.
15, 16, 17.
Yes, please.
17, I'll take notice to respond 1 and 2, man. Kushalappa.
Sorry. BM Kushalappa takes notice for 1 and 2. ಮೂರಲ್ಲೂ ನೀವೇ ತಗೊಳ್ಳಿ.
ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಮಾತ್ರ ನಾಮಿನೇಷನ್ ಬಂದಿದೆ.
ಅದರಲ್ಲೂ ತಗೊಂಡ್ಬಿಡಿ. Next.
Yes, ma'am.
Petitioner in this case. Petitioner is before this on court was challenging. Was the order of the not the RERA authority. Not annexure, not the page 19 not
Challenging the adjudicating authorities.
adjudicating authorities order.
Appellate authority there.
Not either. The reason Lord says not the petitioner was not served with the notice, not with the before the adjudicating authority.
You
It's
can't
a
come
one
on
paragraph order laws wherein not the notice was not served to the petitioner. Not goes ahead with the not direction to say that I have to pay the penalty. The
Page
notice,
number?
Not page number 92. Not. The complainant has filed this case against the respondent, seeking for the delay of compensation. Accordingly, the complainant he has entered into an agreement on so and so with the developer, wherein the developer has agreed to complete the project 2017, the grace period of 4 months. Now the same is not completed, for which the developer has to explain. In spite of notice, he has not been appeared and submitted his stand.
How is the writ petition maintainable? Appellate remedy is available to you.
I'm not on that much, definitely not. I agree there is an appellate remedy. But the one not thing is the notice is served on the respondent's notes, that is the respondent number 3, who was the earlier developer notes, not me.
On that ground, you can take up there in the appellate remedy.
If a liberty is granted not in view of the delay, the statute provides for 60 days.
Section 14 we can always give you, that's all.
Not that. Because I have not been served with the notice also, I'm not to.
All that is there. We
Definitely.
can't be doing.
At least in liberty, I'm not to.
Liberty.
Because of that delay.
ಏನಕ್ಕೆ ಕೇಳ್ತೀರಾ ನೀವು?
Because even the RERA has extended the duration not for the completion.
K. Rajshekar is directed to accept notice for respond number 1, notice to respond number 2 to 8. He is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking the following reliefs. What has been challenged is the order passed by the adjudicatory authority on 19/12/2019.
There is a delay also. Since not the
7 years.
COVID was not, and there the cancellation of the JDO had taken place.
ಅದಕ್ಕೆ writ petition ಹಾಕಿದೆ.
This has been revised not by the authority not extending the time for completion of the project 27.
To place it in the appellate. The petitioner has alternative efficacy remedy in filing. The alternative efficacy. The petitioner remedy in filing is in filing an appeal challenging said order. Writ petition, when a statutory remedy is provided for, is not maintainable. reserving liberty to the petitioner to file appropriate appellate proceedings. Keeping all contentions open, the petition stands disposed.
19, Lokesh Aji.
Yes.
The respondent number 2 has sanctioned loan against the property of the petitioner for a sum of rupees 5 crore 46 lakhs 50,000, my lord, at the interest rate of 12%. However, the loan was disbursed for a sum of rupees 4 crore 63 lakhs 51,530. The interest was charged. The agreed rate of interest is at annexure C1, my lord. Kindly peruse annexure D. This is the interest charged during the tenure of the loan. Annexure D at the page number 65.
Challenging the ombudsman's order.
Yes.
Shri Pradeep Savka is directed to accept notice for respond number 1. Dhani Loans and Services, yaar, standing council yaar idhar hai. IVL Finance and India Bulls. Is there any standing council for respond number 2?
I'm not aware.
ಯಾವುದಕ್ಕೆ? ಅಲ್ಲ ಇದು ಬೇರೆ ಹೊಸದು ಫಾರ್ಮಲಿ ಅಂತಿದೆ.
Earlier it was India Bulls one.
Mr. Xavier? Issue notice to, emergent notice to respond number 2. Why do you want to stay?
No, formally I have
Dismissal. Issue notice, emergent notice to respond number 2 returned by 20th July.
Obliged.
20, Vipin Kumar Jain.
Before petitioner. My lord, the second respondent called for tender. After financial bid, my lords may take page 130.
Second respondent or first respondent called?
First respondent. First respondent. Serial number 370 at page number 130, my lord. The drug is liquid sodium hypochlorite solution, 5%, 5 liter.
Page number?
Page number 130.
130. What document is this?
It is bidders list, my lord, comparative bidders list. As per the product.
Yes, 130.
My lordship code. Serial number 130, my lord. It is sodium hypochlorite solution, 5% liter.
Page 130, serial number?
Serial number 370, 370.
370, yes.
That is
Liquid
sodium hypochlorite solution, 5%, 5 liters. Johnson and Smith, I have quoted 144 rupees, my lord. Pure chemicals, that is respondent number 5, quoted 375 rupees. And in the column L1 is allotted to me, my lord. Johnson is L1.
Is there separate tenders for each one?
No, my lord. It is single tender.
Single tender for all products?
Single tender. And the pure chemicals is L2.
For that product?
Yes, my lord. Post this, my lord, at page 134.
Yes.
The first respondent issues me a email seeking for clarification of the bid, my lord. With reference to the above subject, we would like to bring to your notice a query regarding your price quotation for drug code 430. Please confirm whether your quoted price of 169.92 is 1 liter or for 5 liter can, because it is mentioned as 5 liter can. Kindly provide this confirmation at the earliest so that our office can proceed with the processing. I have given explanation, my lord, at page 135. The relevant portion is, I have mentioned about clause 5.3.2 at page 135, my lord, the mid portion. I take my lord to the clause in the tender.
So it is per liter and not 5 liter?
Per liter. On 4th, my lord, they have next page at page 136. On 4/6/2026, award of contract was given to me for 6 products, among which in page 137, my lord, serial number 5, I am placed as L2. Page 137. I am placed as L2, my lord. No, my lord, I am the lowest bidder as per the comparative table. Now they sought for clarification whether it is for per liter or 5 liter can, because the product mentioned in the tender was 5 liter can. My lord, now what the rules say for quoting the price is at page 40, my lord, 40.
Right, you have quoted 144, 169.92
Per
inclusive
liter.
of tax per liter.
Per liter.
The other person has quoted for 5 liters, 442.
5 liters.
5
They
liters.
seek for clarifications, my lord.
Your calculation comes to 849.6. They are half of your cost.
My lord, yes, because
And sodium hydrochloride is only the glucose.
my lord, at page 40, we are required to quote the price per liter, not for 5 liter or the not per can.
Correct.
It clearly mentions, my lord may see.
You have mentioned for 1 liter, fine. But whatever you mentioned is half of what somebody else has.
It may be, my lord, but
double what somebody else has mentioned.
at the time of quoting the price, I am supposed to quote for 1 liter. It clearly mentions at page
Nobody
40.
is finding fault with that. That is why they asked you for the clarification.
They can't ask for
They
clarification.
multiplied your 169 into 5.
Yes, my lord.
It comes to 849.6. Somebody else has given an offer
Sir,
at
my concern
442.
is they can't ask for clarification itself because the tender rules doesn't permit after
Yes.
financial bid.
They gave you an opportunity to explain. If you are 169 for 5
Even
liters,
they have
you would
not
have
given
got it.
reasons. My lords, kindly take page 40.
Yes.
Everyone is supposed to quote the price for 1 liter, my lord. And the recent decision of the Supreme Court, my lord, after financial bid, they can't change or modify the plan, and they can't seek for
It is not a
clarification
modification.
also.
It's not a modification.
My lord, in this judgment, my lord,
Demands, Yarama.
K. Madhusudan Rao for the respondent.
Madhusudan Rao for respond number 1. Union of India, ASGI for respond. Sorry, Madhusudan Rao for respond number 1, 3, 4. ASGI is requested to accept notice for respond number 2, issue notice to respond number 5, returnable by 14 July. Counsel for respond number 1, 3 and 4 is directed to place on record the bid submitted by respond number 5 and as to whether the said bid is for 1 liter NaCl solution or is it for 5-year NaCl, 5 liter NaCl
my lords,
solution.
may please, my lordship, my lord, Apex Court says they can't change after financial bid.
Mr.
If they
Counsel,
issue word
don't
for-
try to do all these things. You have submitted for 169, for 5 liter has come to 849. You are much higher, double.
Lord, as per their own rules, I'm not supposed to quote for 5 liters, my lord. It clearly, if my lord, one clause I'll show, my lord, page 40.
Nobody asked you to quote for 5 liters. They only asked
lord,
which is 1 liter or
1
5
liter, I
liters.
have quoted for 1 liter. He quoted 1 liter for 340 rupees.
5 liters for that.
No, my
We'll
lord,
get
he
that.
can't
Next.
quote for 5 liters as per rules. He can't quote for, my lord,
Place it on record.
my lord, may kindly see the clause, my lord,
They
because
are not
it's
going to
specified.
state, let them place it, will come.
Much obliged.
Serial number
My lord,
21
a
and
shorter date may be given. I'll take out and summons, my lord. If
And
they
summons returnable by 3rd.
Much obliged.
dates.
serial number 22. R.P. Somshekaraya.
I will prepare petition, my lord. Unanimous direction.
ಯಾರು ಇಲ್ಲ. The request of counsel for the petitioner relist on ಯಾವತ್ತು ಹಾಕಿದ್ದು ಅದು ಇನ್ನು
19-6, my lord. 19-6.
19
sir.
96 ನಾಳೆದ್ದು.
ನಾಳೆ
30th.
Friday.
30th.
Serial number 23. Amit A. Mandagi.
Yeah, the petitioner, my lord. My lords would recollect, my lords, this is the case, my lords. Where,
Not making party of R1. Yes, what is this?
my lords, the senior citizens case, my lords, where the daughter-in-law has been ordered to leave the house.
You made your submission that you are willing to pay.
Difficulty is this one, the urgency from my side is this, my lord. Anyway, we're trying to work some settlement out, yes, I understand. But the problem is, my lord, each time I give a figure, that, my lord, keeps enhancing
Lord,
each
this
time.
submission was made last
I'll make a
occasion.
submission. I'll make a
That is
submission.
why, that is why we recorded it.
Yes,
Yes,
which
my
is why
lord.
it was recorded also. But the problem is, my lord, there was a demand made with regard to Bangalore Club membership. But here, my lord, we are
Oh, my lord,
that
just
is out.
recorded on.
But my lord, now there's a cost of 25 lakhs which is put for that, my lord. Saying that, okay, if you don't give me Bangalore membership, this is what it is.
You have only one question. Very simple. Other, if it's not, argue the matter.
Please, which is why, my lord,
There's no issue about it.
now
You offer 2 crores. Their counter offer is 2.5 crores. Are you ready to give?
2.25 is what I was told.
2.5. 2.5 is what they've asked.
Yes.
He said 2.25 close is acceptable.
But I've come up from 1.5, my lord. This is where I'd started
My
at
lords, even we have
1.5.
come down.
ಇವಾಗ ಏನಪ್ಪ, you
My
are
lords, I'm
acceptable for
seeking-
2.25,
But
not
it will not be possible only because, my lord, in the interim, what has happened is, my lord, because the petition number 2, as far as my petition is concerned, she had to undergo a surgery also because they're, my lord, 82 and 87. Whatever savings, my lord, they have, everything goes in this. It's not as far as the husband is concerned.
We ask you a simple question. Yes or no to for 2.25?
My lord, I will not be able to do 2.25.
ಆಯ್ತು, argument ಮಾಡಿ. Yes.
Before I commence.
Don't come back with a settlement after you start arguing.
No, that's what, that is why, my lords.
Both of you don't
I'm
come
ready,
back.
my lords, to commence my argument. Now, my lords, I'm speaking to my clients. Even today, now, my lords, I've been standing outside and having a word with her. If I could be granted a week's time, my lords, if I can come to a figure that they are agreeable also, my lords, I will trying to convince.
Once you start argument, don't come back.
That is why, my lords, I'm ready. ನಾನು ಇವತ್ತು ready ಆದ್ರೆ.
Learned counsel for respondent submit that the respondent would not be in a position to offer anything more than 2 crores.
I'm sorry, my lord.
Anything, you can't offer more than 2 crores.
Nothing more than that.
And anything more than 2 crores as full and final settlement of all the claims of the petitioner. Counsel for the petitioner seeks for and is granted a week's time to obtain instruction, make a submission as to whether the same is acceptable. If not acceptable, to get ready and address arguments on the merits of the matter. Relist on
My lords, on the 25th,
25th.
highly obliged.
Serial number
Not
20.
25th, not 25th,
Where,
some
what?
difficulty on 25th.
30th.
30th.
Please, please.
30th.
Please.
Oblige.
Serial
Highly
number
obliged.
24 urgent, 25. MB Chandrachuda.
Shri MB Chandrachuda has appeared for the petitioner, hence the memo of retirement filed by Shri BC Sitamarao is accepted. He is discharged from the matter. Registry Direct delete his name as that appearing for the petitioner.
Pray for 2 weeks accommodation is so.
Counsel for the petitioner seeks for and is granted 2 weeks' time. Objections file ಆಗಿದೆಯಾ?
Objections file. This is the same case, my lord, where there was an order of this honorable court, my lord, 30/10/2025 to pay some amount, the admitted amount. The remaining they have to challenge before, as per the last date of hearing. my
My
lord.
client is not, I will make my submission, last night.
These are all contractual matters.
I will make my submission.
Seeks for and is granted 2 weeks' time to get ready and address his argument. Relist on 10 July, it is made clear that no further
By
agenda.
that time, let them file objection if any.
Our objection is only contractual matter, writ petition not maintainable.
Clause 29, my lord.
All right.
ಅಷ್ಟೇ our objection.
Please.
Clause 29. Please.
Submission of learned counsel for respondent that he does not wish to file written submission.
ಬೇಡ ಸ್ವಾಮಿ, ಹೇಳ್ಬಿಟ್ಟು ಇದ್ರೆ ನಾನು ಹಾಕ್ತೀನಿ, ವಿತಿನ್ ದಟ್ ಟೈಮ್ ಬೇಕಾದ್ರೆ ಹಾಕ್ತೀನಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ.
ಇದು ಹೇಳ್ತೀರಾ ಅದು ಹೇಳಿ.
ಅಲ್ಲ, ಹಂಗಲ್ಲ.
Who is another? Prashant Bihar is appearing for one. Another ಯಾರು ಇದ್ರಲ್ಲಿ?
Executive engineer, Hemavati.
I am appearing for
ಅವ್ರಿಗೂ ಇವರೇ ಅಪೇರ್ ಆಗ.
ಬರೀ R1 ಗೆ ಹಾಕಿದ್ದೀರಾ?
first and two, first and second, both I am appearing.
Prashant Bihar, who has filed Wakalatnama, accepts notice for respondent number 2 also.
Please.
He seeks for and is granted a week's time to file a statement of objection, objections if any, by 30th June, released on 10 July.
Please.
Please.
Serial number 26.
I appeal for respondent number 5, your lordship. Not get the file today, your lordship, misplaced file.
5 and 4 ಗಿದೆ.
26, 4.
26.
Yes, sir.
Connected matter ಬೇರೆನೆ.
Yes, sir. Can I request your lordship?
Connected matter ಏನಿದೆ?
Allegations of professional misconduct.
26 ಕೊಡಿ, ಎಲ್ಲ ಸರ್ವಿಸ್ ಆಗಿದೆಯಾ?
ಸರ್ವಿಸ್ ಆಗಿದೆ. ಎಲ್ಲರಿಗೂ ಸರ್ವಿಸ್ ಆಗಿದೆ. Last occasion the matter.
ಅಲ್ಲ 26(1) ಅಲ್ಲಿ ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ. 26(1.1)
21.1 ಅಲ್ಲಿ ಆಗಿಲ್ಲ.
Names are not been shown.
You are appearing, madam?
For respondent number 1 in 26.
Ms. Kritika Raghavan has entered appearance for respondent number 1, delete name of Shri Ms. B.V. Vidilata is that appearing for respondent number 1. V. Natraj, G. Natraj, registry is correct the appearance of the counsel for respondent number 2 as Shri G. Natraj. Learned AGA.
R3.
Accepts notice, agide. 4, you are appearing for Girisha TV.
Yes.
Yes, sir.
Copy on the
Complete.
Copy not served. Served, not served. ಇನ್ನ ಆಮೇಲೆ ಮತ್ತೆ ಇನ್ನೊಂದ್ಸತಿ ಬೇಡ ಇದು.
I will take copy one more.
If not, give one more copy. 26.1 ಕೊಡಿ.
June 2nd, my lord.
26.1, Shri G. Nataraj is directed to accept notice for respond number 1. Shri S.C. Shivaramu accepts notice for respond number 2. Ravi Kumar BSG. No, you are there.
Is there, my lordship, you have certain.
No, you are appearing for them.
Who's
Ms. Nagratna K. accepts notice for respond number 3. In that view of the matter, there would be no requirement for making payment of any process fee. IA 1 of 26 is allowed, 2 of 26 is allowed, 3 of 26 is allowed. Yes, objections?
Yes, in fact, last week, the last occasion, the matter had come up, since this is between the lawyers and the clients who will ask you for payment of professional fee. After arguing some time, my lord, this court suggested up to MFA year, before this court, my lord, the lawyer invested the amount and engaged the counsel at here also, got the amount enhanced, my lord. And it is in that background, court suggested, my learned friend, my lord, orally suggested, my lord, you pay some 4 lakhs rupees and get it settled. Sit with other counsel and finally settle it. That's what they said.
All of you are willing to settle, we have
But
nothing to do.
transferred your
No,
lordship.
we don't have any say, my lord.
That's
You want
what
to
it was
settle, you
transferred.
settle.
I was
Dispute between
I
the
was
client
there,
and the
my lord,
lawyer.
arguing the matter. It was suggested to my learned friend also. Afterwards, my learned friend did not make up my mind.
Is there any settlement happening?
My lordship, the court was left on the respondent side, but the respondent did not approach us. We are ready for settlement. As per
All
the
right, I
prayer,
will-
my lordship, withholding 10%, this court may dispose the petition, my lordship. And since
We are not going to pass any order on
Like that in writ petition. 226 ಅಲ್ಲಿ ನಾವು 10% ಎಲ್ಲ cut ಮಾಡಿ.
against me also before the bar council, just for the mistake.
That's a different.
Petition here, my lordship. Apart from that, I have not done anything.
What both of you done is completely wrong.
My lordship, I have not done anything.
What all of you have done is completely wrong. There is no contingent fee system in India. What all of you have done is completely wrong. If we have to decide on it, we'll decide on it.
If we pass over, my lordship, we'll sit around and we'll.
We are not going to allow anything. We'll pass orders on the merits of the matter after hearing you.
Much obliged, my lordship.
If you settle it and you're withdrawing it, is up to you. But if you want to argue, please argue.
Last fight. My lordship.
Paso,
Please hear the-
you don't hear, you argue well here.
I don't have file in my hand, my lord. Therefore I made a submission in the beginning itself. my lord.
A file is not there, give them the file.
ಅದಕ್ಕೋಸ್ಕರ ಅಲ್ಲಲ್ಲ ಇದೆಲ್ಲ ಇನ್ನೊಂದು ಫೈಲು ಮೇನ್ ಫೈಲ್ ಇಸ್ ದೇರ್ ದಟ್ ಫೈಲ್ ಇಸ್ ನಾಟ್ ದೇರ್ 27,943 of 2026 my lord. So 25 today it was misplaced your lordship, that's why I could not get the file in the beginning.
Yes,
That's why I made a
seeks
submission.
for and is granted 1 week's time finally
Ask
to
my client to be present, my lord, to ask.
whatever you want to do, we are not going to get involved.
Yes. I humbly plead, I humbly beg you for this court. This court may please pass interim orders, my lordship, since he is left on the streets, my lordship.
Mr. Counsel, when we deal with this matter, he may not be in the streets, he may be somewhere else. Please understand the seriousness of what all of you have done. You can't be doing these kind of things. So it's up to you. You want to address arguments, please do. Shri S.C. Shivaramu seeks for and is granted a week's time finally to get ready and address his arguments. Relist on 25th. It is made clear that no further adjournment would be granted if the arguments of the counsels who address arguments on that day would be considered and orders passed.
25th, 29th, my lord.
Or urgent on 25th. Yes.
27. Abhishek, please.
27 minutes. There was an interim order, my lords, that was operating. Let's see if my lords may see the order sheet, my lords, on 2/6/2026. It is made clear, para 3. On 2nd of June, my lords, it's made clear that no further adjournment will be granted if arguments are not advanced by the petitioner the next day. The petitioner would be liable
There's
to.
no
be
value
dismissed
for this order if we accept your. We'll dismiss it, file a recall application and come. Despite the order dated 2/6/26, in pass over dismissal. Adjournment illa. Pass over.
28. Vijay Kumar.
ರವಿಶಂಕರ್ ಅವರು ಬಂದಿದಾರಾ? ಪಾಸು ಅವರ? ಪಾಸು.
29, Srinivas here.
On 2/2/26.
ಒಂದು ಗೌರ್ಮೆಂಟ್.
To secure any residence. So that's on basis of this, we not such an affidavit on 17 February.
17?
I swear to the PhD bank, because senior citizen will get more interest in PhD bank. So an amount of rupees 12 lakh request 10,000 rupees per month. So my lord, the respondent also, if she opens account there, it will be helpful for me to deposit the 12 lakh there and transfer the interest to an extent of 10,000 per thousand. So I can get back the possession of my property, my house.
Yes.
My lord, I am appearing for respondent number 5. I would like to repeat my submission that this petition is not maintainable, my lord, under Senior Citizens Act against a daughter-in-law. Senior Citizen Act section
May not be now available for you to make the submission after all the orders which have been recorded.
even the last time also
You
I
are
made a
agreeable that he
submission
deposits
and
the money, he is ready to deposit and give you 10,000 rupees a month. After all the acquiescence on your part, you cannot be raising this issue
my
now.
lord, we have not agreed for the offer which they have made. It is the
We'll place
orders
it
of
before
my
the,
lord.
we'll place it before the same judge for consideration. Because the same
My
judge will
lord, if
spend
you
so much
permit me, I'll
time,
just make 2 submissions.
not on, we won't hear you on merits of the matter. Only on the request that
Even
you have
on
made,
merits also,
that much you can submit.
even on merits also, one is the Tahsildar has given a report.
Merits, we won't hear you because the coordinate bench has spent so much time and recorded all your submissions.
And
Just because the bench changes doesn't mean that you change your stand.
no, we have been
we
consistently,
can
with the-
send
as far
back-
as the affidavit is concerned, I'll make submissions on the affidavit. My lord, that is around 42 kilometers from the village where she is staying. And PLD Bank is not a bank which maintains accounts of customers. It is a land development bank, which is basically for
That you can make your
development loans given to land.
If that is the case, because
And-
I can make an arrangement for transfer from my account to anywhere.
ಅದೇ ಬರಲ್ಲ ಬ್ಯಾಂಕ್ ಇದೆ. ಅದೇ ಬರಲ್ಲ ಬ್ಯಾಂಕ್ ಇದೆ.
Not an issue.
What the,
So ನಾನೇನು ಕಲ್ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀನಿ ಅಂದ್ರೆ because my lord being a citizen, ಆ 12 lakhs for this particular, there's a more difficulty that they are doing that. So
give a nationalized bank,
Yeah.
interest ಅಷ್ಟು ಇಲ್ಲ.
ಪರವಾಗಿಲ್ಲ, ಜಾಸ್ತಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿ.
5 ಲಕ್ಷ ಜಾಸ್ತಿ ಆಗ್ತದೆ.
ಮಾಡಿ. ಪ್ರಾಪರ್ಟಿ ಬೇಕು ಅಂದ್ರೆ ಮಾಡಿ.
ಅಲ್ಲ, ಏನಾಯ್ತು?
Not these kind of bank.
Yeah.
Scheduled bank, nationalized bank, yes.
ಅದೇ ಬರಲ್ಲ ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಆಫ್ ಇಂಡಿಯಾ ಇದೆ.
Not a non-scheduled bank ಬೇಡ.
In fact, I will do that. That's, ಸ್ವಲ್ಪ ಕಷ್ಟ ಆಗ್ಬೇಕಂತ I will advise them. I will
ಯಾವಾಗ ಮಾಡ್ತೀರಾ?
next 10 days.
My lord, same village, State Bank of India branch is there.
ಅಲ್ಲ.
It will be easier for
Does
us.
it matter where the bank is?
Hey,
It comes into your account.
Yeah, but she has to travel to withdraw or.
ಬೇಡ. This is a standing instruction.
My lord, they charge for that. Banks charge for the standing instructions. Suppose if it is the same bank,
Net of everything, 10,000 has to come to your account is the order.
every
Whatever
month,
charges they will bear.
then your lord makes an order accordingly, then it will be fine. Because every month, whatever the charges, they'll be deducting and
All these submissions you can make.
minus ಮಾಡಿ ಕಳಿಸ್ಕೊಡ್ತಾರೆ, my lord.
10,000 net of everything you should get.
Not a single penny ಕಡಿಮೆ ಆದ್ರೆ 10,000.
ಅಷ್ಟೇ. An affidavit of the petitioner has been filed stating that the petitioner had made enquiries with the PLD Bank Caste branch Tumkuru and that the petitioner is willing to deposit the money with their standing instructions to transfer an amount of rupees 10,000 to the fifth respondent's account in the same bank every month on a date to be fixed by this court. Learned counsel for the respondent number 5 submits that the said bank, what bank is it? PLD Bank is located at a distance of 42 kilometers from the residence of the fifth respondent.
From the
And as
village.
such, it would be inconvenient for respondent number 5 to visit the said bank for withdrawal of the amounts. His submission is that if the deposit is made in any bank of the choosing, any nationalized, any bank of the choosing of the petitioner, which is a nationalized or a scheduled bank, the petitioner would not, respondent number 5 would not have any objections. So long as the instructions are to transfer the amount to the account of the petitioner in SBI.
Respondent 5.
Respondent number 5 in State Bank of India, ಯಾವ branch?
State Bank.
ತೋವಿನಕೆರೆ ಅಲ್ಲ? State Bank of India,
Tovinkere, fifth
Tovinkere branch. Tumkur district, Tovinakere.
Tovinakere, Tumkur district. Tovinkere branch to Tumkur district.
Tumkur district.
Learned counsel for his further submission is that the transfer should be of a sum of rupees 10,000 net, excluding any bank charges otherwise. Counsel for the petitioner seeks fund is granted
2 weeks.
2 weeks time to do the needful. An affidavit or a letter of the bank manager to be also placed on record.
Along with the receipt of that deposit.
Allah, standing instructions that they will honor. The affidavit and or a letter from the branch manager of the bank where the petitioner were to deposit the monies to be filed, indicating that the deposit has been made and the standing instructions would be complied with on a month-to-month basis till eternity.
Yes, because what happened is, my lord, there is a difference and that family proceedings going on between my son and daughter-in-law. That's all 25 considerations. Here, my lord, after vacating the premises, the 10,000 will be deposited. Because my lord, I deposited, I transferred the amount, she is not vacated my premises.
That will ensure that is why the court is there, to ensure both of you do what you have to do. The counsel is also there. That takes only one visit of the assistant commissioner to Tahsildar to implement it. That is not indicating that that an amount of rupees 10,000 net would be transferred to the account of respondent number 5 in perpetuity till her lifetime and or subject to any orders being passed in any other proceeding.
Because there are the difference between going on maintenance proceeding proceeding.
And subject to any other proceedings. ಅದಕ್ಕೆ ಅದನ್ನು ಹೇಳಿದ್ವಿ, ಎರಡು ಹೇಳಿದೀವಿ. ಇಲ್ಲಿ ಲೈಫ್ ಟೈಮ್ ಅಂತ ಹೇಳಲೇಬೇಕು ನಾವು. If any order you get elsewhere, when you may end up with a different compromise, who knows? Released on 25th.
10,000 is after vacating. Standing instructions for that.
The submission of learned counsel for the petitioner is that the transfer of 10,000 would occur only after respondent number 5.
They will be filing the affidavit with the details.
Submission of learned counsel for respondent number 5 is that once the letter is furnished, the respondent number 5 will vacate within a period of
period of ಒಂದು ಎಷ್ಟು ದಿವಸ 15 ದಿವಸ ಸಾಕ 15 ದಿವಸ ಅದೇ ಹೇಳಿ ಬೇಗ ಎಲ್ಲ. 4 weeks, my lord.
Within a period of 3 weeks.
3 weeks.
Of the letter being filed. The submission of the respective counsels are placed on record. 25th. Previous counsel.
Serial number 30, Monesh Kumar.
In light of page number 52, petitioner commits murder is suffering from cancer. For 9 months, they have been waiting for the detection. So the address where there's 2 pending cases, I will not person premature investigation.
ಯಾರ್ರೀ ಬರ್ದಿರೋದು ಇದು ಸರ್ಟಿಫಿಕೇಟ್? Do the resident medical officer writing like this? WHOME, whom? Is certified she is suffering from SCVIER. In doctor English baralva. She wants immediate surgery. Not the doctor has advised, she wants. We are getting a lot of fake certificate, that's the problem. And this seems to be, verify the genuineness of this. And AGS is granted 2 days time to verify the genuineness of Annexure F certificate, released on 22nd.
31, serial number 31, Sirajuddin Ahmad.
General parole. Certificate ಎಲ್ಲಿದೆ?
Page number 17, Lord. 18 is the type copy.
You're not been granted parole earlier.
Granted, Lord.
Where are the details?
Details.
Parole, yes, here. 1 year, 11 months. Yes.
No adverse remark, Lord.
Any objections? Any objections?
22nd. 22nd. Motion 22nd.
ಏನಕ್ಕಪ್ಪ? ಇದು ಆಲ್ರೆಡಿ ಸರ್ವಿಸ್ ಆಗಿರೋದು. He's been granted parole earlier for 1 year, 11 months, 13 years, yes.
No adverse remark.
There's no adverse. Third. Petitioner, wife of Wasim Pasha, CTP 17866, is before this court seeking for the following reliefs. CTP 17866, bracketed detenue. The detenue had been convicted for offences
302.
Under section 302 of the IPC in SC number 220 of 2011 by FTC 4 Court, Mysuru, for imprisonment for life, wide judgment and sentence dated 28/5/2013. The detenue has been incarcerated for a period of 13 years, 11 months, 11 days, as on 15/12/2025. The petitioner, the detenue applied for parole on the ground that who is Nayan Taj?
Mother, Lord.
That is mother had a cerebrovascular accident, bracket stroke, and is undergoing medical care. The said request having been rejected by the respondent, the petitioner is before this court seeking for the officer relief. A parallel of the papers indicates that there is a certificate issued by the Mysore Hospital certifying that the mother of the détenu has suffered a cerebrovascular accident. The imprisonment certificate indicates that the petitioner, that the détenu has been incarcerated for a period of 13 years, 11 months, 11 days, and he has been granted parole on several earlier occasions for a period of 1 year, 11 months, 1 day, during which period there is no particular complaint against the détenu. The conduct of the détenu has been satisfactory, there being no complaints against his conduct. In that view of the matter, considering that the petitioner has served nearly 13 years, more than 13 years, nearly 14 years, served more than 14 years as on date, and had been granted parole on several occasions earlier, the application of parole submitted by the détenu could not have been rejected in the manner as done. As such, I pass the following order. So and so, for a period of 60 days commencing from 24th June.
Serial number 32, adjourn 33.
My lords, I appear for the petitioner, my lords. Going for respondent number 30 and 14, my lords. My lords, seek a short indulgence of this court, my lords. Senior is held up in court on number 19.
Pass over.
My lords, I may make one submission. They may file their reply, my lords. They have not yet filed my reply. An emergent notice may be issued to the other respondents, my lords. Respondent number 1 to 5 and 14 are on record. The remaining emergent notice may be issued, then the matter may be taken up, my lords.
1 to 5 is the state.
And 14 also was on caveat.
13 to 15 are there. 13, 14, 15. So 6 to 12. Issue emergent notice to respondent number 6 to 12, returnable by 20th July. In the meanwhile, statement of objections to be filed.
Let them file their objections also, my lords, if they have.
That is what we said in the meanwhile.
Please, my lords.
To be filed on or before 14 July, failing which will be taken as not filed in matter proceeded.
Please, my lords. Extremely grateful.
34. Raju, yes.
Yes, Mr. Raju. Yes, Mr. Subramanian.
Lords, this honorable court, my lords, passed an interim order. It's on 12th of March, my lords, 2026.
Order sheet? Order
sheet.
12th of March. Directions issued by the Lokayukta. You have to place on record the directions issued by the Lokayukta.
Records are available. Records are available.
Directions copy kodi ashte ella file enake.
Next year.
ಇಲ್ಲಿ ಲೋಕಾಯುಕ್ತ ಕರೆಸ್ಪಾಂಡೆನ್ಸ್ ಇಲ್ಲಿದೆ. ಹಾ, ಇಲ್ಲಿದೆ. The Lokayukta asked for a report as regards the site and your ownership
Kindly see
on
notes.
31/26.
Annexure M may kindly see.
Kodi documents, Kodi, they will
Notes
submit a
now.
report to the Lokayukta.
Lords, one aspect, my lords, which I would like to, my lords, bring to my lords' notice. Lords, they are asking for, my lords, the title deeds.
Copies, Kodi.
Copies, Kodi, title deeds. My lords, do they have the authority, my lords, to verify, my lords, the title deeds?
The allegation is that this property belongs to the BDA and the BDA property has been occupied by you unauthorizedly.
Please.
And several other allegations are there.
My lords, kindly see, my lords. May just draw my lord's attention to page 40, my lords, Annexure M.
Subramani, you have to cooperate with the inquiry being done by Lokayukta as regards. This is a public property.
Lords, if
according to them,
yes, lords,
you place on record that it's your private property, they'll accept it and submit a report.
Lords, apart from that, lords, my respectful submission, lords, is that this is a case where, my lords, I traced my title, my lords, from 1974.
Kodi papers, Kodi.
That I have placed on record before this honorable court.
ನಮಗೆ ಏನಕ್ಕಪ್ಪ ಕೊಡ್ತೀರಾ? ನಾವು ಎನ್ಕ್ವೈರಿ ಮಾಡ್ತಾ ಇದೀವಿ.
No, lords, it is not that, my lords.
ಕೊಡಕ್ಕೆ ಹೇಳಿ ಕೊಡ್ತಾರೆ.
Now the issue, my lords, is that one of the person, my lords, who wanted the my lords, I have two sites. One site, my lords, is vacant and where, my lords, I am parking the vehicles, my lords. Now, my lords, he wanted that particular space, my lords, and I refused to sell it. But now somebody, my lords, they say that road.
You are challenging their notice.
Yes.
They are acting in terms of the directions issued by Lokayukta. If you are not, that is not under challenge.
That they did not provide, my lords, these details, so that, my lords, I could also, my lords, even challenge, my lords, the authority of even the Lokayukta, my lords, whether such an inquiry should be conducted.
Notice ಅಲ್ಲೂ ಹೇಳಿದಾರಲ್ಲ.
ಇಲ್ಲ, ಅದರಲ್ಲಿ ಕೇಳಿದೀವಿ ನಾವು, my lords, that is at annexure K and M. In annexure K, my lords, they don't provide anything at page number 38.
ಲೋಕಾಯುಕ್ತ ಅಂತ ಹೇಳಿದಾರಲ್ಲ.
ಲೋಕಾಯುಕ್ತ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದರಲ್ಲಿ ಏನ್ ಕಂಪ್ಲೇಂಟ್ ಇದೆ ಅಥವಾ ಲೋಕಾಯುಕ್ತ ಕೇಳಿರೋದು ಏನಿದೆ? Lords, those documents have never been, lords, given to us.
They have told you it is because of the Lokayukta inquiry.
In annexure M also, lords, they say that street people and social workers.
Give him copies of the letter received by you from the Lokayukta. That's all. We'll dispose of this matter. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner was that the respondent police was acting at the behest of certain private parties and had issued a notice on 16/2/26 at Annexure K, calling upon the petitioner to furnish documents relating to the property belonging to the petitioner. The submission of Sri R. Subramania, learned senior counsel appearing for the petitioner, is that the same having been done at the behest of private parties was not maintainable. It is in that background that the coordinate bench of this court had called upon the learned AGA to secure instruction, make a submission. Today, a file has been placed, the original of the file relating to the above has been placed on record. Perusal thereof indicates that a complaint having been filed before the Honorable Lokayukta, the Honorable Lokayukta has directed the respondent to carry out necessary inquiry and submit an inquiry report. And in furtherance thereof, that notice had been issued to the petitioner. Hence, the action taken by the respondent is not at the behest of private parties, but on the instructions issued by the Honorable Lokayukta, which cannot be found fault with. Then AGA is directed to furnish copy of the complaint received by the Honorable Lokayukta, as also the correspondence received by the respondent from the Honorable Lokayukta to the petitioner within respondent is director AGL within a period of 10 days from today. Since the action taken by the respondent is in pursuance of the direction of the Honorable Lokayukta, the above petition does not survive for consideration, reserving liberty to the petitioner to agitate all his rights before the appropriate forum. The petition stands disposed.
Very good.
The original file is returned back to the land AG.
35. Rajesh Rao.
This Mr. Jagdish.
For petitioner, my lords, challenging the impugned order, annexure C, my lord, cancelling the caste certificate, my lord, alleging that I have obtained the caste certificate by false remedy.
Cancelling.
Annexure C, my lord. Kindly see.
By who has passed this order?
Deputy Commissioner Udupi, my lords.
Caste Review Monitoring Committee.
Please, my lord.
My lord, I am appearing for special counsel C. Jagdish, my lord. My lord, it is the appealable order under section 4D of the Karnataka SC/ST Act, my lord.
This is passed under 4C.
Yes, my lord.
Annexure C.
My humble submission, my lord. Kindly see annexure C, page number 13, bottom, my lords, bottom, last line, last para. ದಿನಾಂಕ 25/8/25 ರಂದು ಶ್ರೀ so and so, that is the late father of my petitioner, my lord, ಬಿನ್ ಮಂಜುನಾಯ್ಕ ಅವರಿಗೆ ಸದರಿ ವರದಿಯ ಬಗ್ಗೆ ತಮ್ಮ ಆಕ್ಷೇಪಣೆಗಳು ಏನಾದರೂ ಇದ್ದಲ್ಲಿ ಅಗತ್ಯ ದಾಖಲಾತಿಗಳೊಂದಿಗೆ ಲಿಖಿತವಾಗಿ ನೀಡಲು, ಇಲ್ಲವಾದಲ್ಲಿ ತಮ್ಮ ಆಕ್ಷೇಪಣೆಗಳು ಏನು ಇರುವುದಿಲ್ಲ ಎಂದು ಪರಿಗಣಿಸಿ ಮುಂದಿನ ಕ್ರಮ ಕೈಗೊಳ್ಳಲಾಗುವುದು ಎಂದು ಪತ್ರ ಮುಖೇನ RPID ತಿಳಿಸಲಾಗಿರುತ್ತದೆ. ನೆಕ್ಸ್ಟ್ ಪೇಜ್, my lord. ಶ್ರೀ ಈಶ್ವರ ನಾಯಕ್ ಬಿನ್ ಮಂಜುನಾಯ್ಕ ಅವರು ನಿಧನರಾಗಿರುವುದಾಗಿ ಅಂಚೆ ಇಲಾಖೆಯಿಂದ ಪತ್ರವು ಹಿಂತಿರುಗಿರುತ್ತದೆ. No notice is served to me, my lords. Despite of that, they have passed the order.
No notice has been served, madam, on the petitioner?
No, my lords. That is the issue, my lord. So the appeal does not survive for me, my lords.
My lord, ಅದೇ ಸೆಕ್ಷನ್ 4D ಕೆಳಗಡೆ ಅವ್ರಿಗೆ ಅಪೀಲ್ ಮಾಡಕ್ಕೆ ಅವಕಾಶ ಇದೆ, my lord.
4D ಗೆ ಇವ್ರಿಗೆ ಸರ್ವಿಸ್ ಆಗಿ ನೋಟಿಸ್ ಅಪಿಯರ್ ಆಗಿದ್ರೆ yes. National justice has not been complied. Get instructions from your senior. We'll set it aside, remind it, direct him to place the documents on record, and you pass fresh orders. Please.
Please.
Get your instruction from your senior. Pass over.
Any?
Please.
Number 36. Ashok Tripathi.
I'm for the petitioner, my lord.
Yes.
Pay for the respondent.
R2 is deferred.
My lord, in this, there is another writ petition pending before this on-writ court in WP 23218 of 2024, in which the respondent number 2 herein is also a respondent in that matter.
In the voters list.
Lord, that has no bearing on the, my lord, this petition.
My lord, the statement of objections filed by them.
Voters list we cannot direct, madam. You have to file a civil suit.
Please.
My lord, that both writ petitions may kindly be tagged because, my lord.
Both will have to dismiss on the same day.
My lord, kindly. The statement of objections.
You take one dismissal today, next dismissal the other day.
No,
this is not maintainable.
Kindly, my lord. The statement of objections filed by the respondent number 2, my lord, they say that since there is a stay in the other writ petition is the reason why the membership forms of the petitioners here are not.
Lord, that has no bearing.
Lord, dismiss both
Lord,
of them.
here the problem
day.
that, my lord, because of Lord intervention of this court, my lord, there is no, my lord, the counting of the, my lord, the paper.
ಆಯ್ತಪ್ಪ ಯಾವತ್ತಿದೆ ಅದನ್ನ ಡೇಟ್ ಇದೆಯಾ ಆ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ?
ಡೇಟ್ ಇಲ್ಲ, ಅದು ಬಂದ್ಬಿಟ್ಟು ಏನಾಗಿದೆ, my lord, that's the issue, my lord.
So and so released on 19th.
My lord, I'm passing the memo, my lord.
Yes.
I will number.
Next.
Serial number 36, 37.
My lord, date kindly on
19th.
29th.
You can't ask for that kind of a time when voting is held up.
Please.
37.
Yes.
The order dated 25/3/26 mechanism.
25/3.
3/20/26. Para 2.
Explanation. Interfering with the dispute between flat owners.
These are the photographs, my lord, which were taken. Ladies were manhandled. Ladies went to the police station and said, "We are being manhandled." These are the photographs on the day what has happened. Despite that, they did not register their.
Why did you go to the police station when you say they should not go?
Prior to that, ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಆಗಿದೆ. ನಮಗೇನಿಲ್ಲ FIR ಹಾಕಿದ್ರೆ ಮುಗಿತು. We have nothing against my lord.
ಗಿಡ ಕಿತ್ತಾಕಿದ್ದಾರೆ ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತಾರೆ ಸರ್.
Is the allegation that you make?
And we have nothing against my lord, the officers. If
You are saying police should not interfere. You only go to the police for giving a complaint.
prior to that,
Even prior to that.
what had happened, my lord, there is a small history to this. This is a apartment complex, my lord, where they were proposing to construct a Ganesha temple. Few of the, my lord, miscreants who had, my lord, created certain ruckus in the apartment, and my lord, they were certain, my lord, acts
To
which were-
file a civil suit, Mr. Deshpande.
That I'll do, my lord, but the only
If you have a
submission,
complaint against your fellow apartment owners, file a civil suit,
that, my lord, on that time, my lord, I have no, my lord, I'm
not
at
criminal
that.
proceedings.
As regards, my lord, this holding of this, my lord, threats, sir. Not a clear case with that is what I'm saying. Let them investigate and, my lord, let them come up with any report.
No.
These photographs, if my lords were to see on the day what had happened.
Yes.
these photographs
Saplings were
kindly-
planted in common area. Is
Common
your
area ಅಂತ ಅವ್ರು
allegation.
ಹೇಳ್ತಾರೆ.
That's your allegation.
ಅಲ್ಲ, my complaint, my lord, your lordships may kindly see what I've written.
I have forcibly uprooted the people's tree sapling which was planted in a common area of said apartment. It is also alleged that the accused person uprooted people's tree because it belonged to Hindu
Subsequently, my
community
lord,
and apartment owners.
Subsequently, my lord, one more development took place. And we met the DCP and we filed the complaint. Few of the ladies were manhandled when they were carrying the Ganesh.
Did you file the complaint? You file a civil suit.
My lord, as regards civil suit, my lord, the filing of civil suit, my lord, it appears subsequent to passing of this order. One of the, my lord, apartment owner had approached the civil court, and, my lord, certain interim orders were issued. And now, my lord, here in this fresh, my lord, cause of action, what we are saying, my lord, offense under section 509, my lord, and 285 are.
The apartment living is community living.
Yes.
If you want to live in an apartment, live as a community. Otherwise, get an independent house, do whatever you want in your house.
What I'm alternatively submitting before your lordship is the
Every man's house is castle, you can be in the castle. But if you're living in a community, you have to live as a community. You have to be with everybody. You can't be going and filing complaints and the police looking at apartment owners this one. If you have any issue as regards uprooting of trees, putting of shoes outside the door, parking of the car.
We have no issue with the parking.
ಅವೆಲ್ಲ ಬರ್ತಾ ಇದಾವೆ ನಮ್ಮ ಮುಂದೆ. ಅದಕ್ಕೆಲ್ಲ ಹೋಗಿ ಪೊಲೀಸ್ ಕಂಪ್ಲೇಂಟ್.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ವಾಟ್ ಐ ಪಾಯಿಂಟಿಂಗ್ ಔಟ್ ಇಸ್
ನಾನು ಎಲೆಕ್ಟ್ರಿಕ್ ಕಾರ್ ಚಾರ್ಜರ್ ಲೊಕೇಶನ್ ಅವ್ರ ಕಾರ್ ಬಂದು ನಿಲ್ಲಿಸ್ಬಿಟ್ರು ನಂಗೆ ಚಾರ್ಜ್ ಮಾಡಕ್ ಆಗ್ಲಿಲ್ಲ. These are not for which you can file police complaints. These are all your neighborly disputes. If you have civil dispute, file a suit, go to the court, then you will know.
If that report, my lord, learned fund is producing, they withdrew the complaint against us, and, my lord, as regards us, my lord,
Petitioner is before this court, seeking
affidavit
for
is
the
also not
following
forthcoming,
reliefs.
as there.
A perusal of the complaint filed by the petitioner indicates that the said complaint is as regards certain persons having forcefully uprooted people's tree. People's tree ಅಂದ್ರೆ ಏನಪ್ಪ?
People's tree ಅಂದ್ರೆ this is, my lord, ಅರಳಿ ಮರದ್ದು.
People, Hindi people.
ಅರಳಿ ಮರ.
English ಅಲ್ಲಿ ಏನು ಅರಳಿ ಮರಕ್ಕೆ?
ಅರಳಿ ಮರ, banyan tree, banyans. ಆಲದ ಮರ ತರನೇ.
ಆಲದ ಮರ ಅಲ್ಲ.
ಅರಳಿ ಮರ. ಒಂದು ನಿಮಿಷ ಸುಮ್ಮನೆ. People's tree.
People tree ನೋಡಿ English ಅಲ್ಲಿ ಏನಿದೆ?
ಒಂದು ನಿಮಿಷ.
Indian people. Sapling planted in a common area. And it's on that basis the complaint was sought to be filed before the jurisdictional police and the jurisdictional police had been called upon to register a FIR. Any dispute inter se between the apartment owners is a civil dispute and cannot be given a color of a criminal dispute as sought to be done in the present matter. A apartment complex would require community living, and the residents of the said apartment complex have to live in harmony with each other. The filing of criminal complaints does not augur well for such community living, and that too as regards a matter which is ex facie civil in nature. Giving a tint of criminality to a civil dispute cannot result in this court directing by issuing a mandamus to register a FIR. appropriate forum. The petition stands dismissed.
Only one last additional submission that we are making. The complaint that we had filed before the DCP, this complaint which my lords are saying. Not in that complaint, my lord, we had provided them the CCTV footage, wherein, my lord, one of the lady was slapped. He was virtually stabbed.
Where is that lady? She is not before us.
No, my lord, we kindly see the complaint which we had.
Where is that lady? Let her give a complaint,
That observation we can.
not the association.
Oh, the association.
If there are
has no
any individual grievances, it would always be available for such individual to file necessary complaint.
ಅದೊಂದು ಬಂದ್ಬಿಡ್ಲಿ
ಅದೇ ಬರ್ದಿದೆ.
ಯಾಕಂದ್ರೆ ವಾಟ್ had happened, my lord.
ಬರ್ಕೊಂಡ್ರಾ? If there are any individual grievances of any person, it would be for that person to file appropriate complaints by making such appropriate allegations. Actually, don't do this association business. And
Serial number 38 dismissed, 39.
Correct.
Tejasvi KV.
9.1 for the petition.
Yes.
Yeah, for petition. Proposed to respondent number 8, madam.
23, 21.
Lots
This 21 matter, 23 matter.
Lots in writ petition number 26232 of 2022. Lord, the respondents have filed an objections, my lords, for which we need to file a rejoinders, my lords. That is 39.2.
39.2,
my lords.
One nimisha. 39 AGA for all the respondents, Allah. There is no private respondent. You have filed your objections, Jafar? 39.
39, my lord. In that, my lord, their appeal was dismissed by the statutory authority on the ground of limitation, my lord.
You want to file any objections in this?
Yeah, my lord, it's, we have to file objections, my lord.
You will argue on the basis of the records.
Well, I will file the objections, my lord. But only thing is, my lord, the first petition, my lord, the first petition, that is 39, is an dismissal of an appeal before the statutory authority on the grounds of limitation.
Aitu.
The second one, my lord, is the.
In the first one, do you want to file any objection?
Yes, my lord, because there's a delay of 5 years.
1 out 26 is allowed. And AGA 6 fund is granted 2 weeks time to file a statement of objection. 39. 39.1 Kodi. Shri R. Kiran has entered appearance for the petitioner. Registry is direct to the name of Shri Sripada Venkata Jogarao as that appearing for the petitioner. Service complete agreement. Ashu agreement for 1, AGA for 2 and 3. Idರಲ್ಲಿ objections file ಆಗಿದೆಯಾ?
ಇಲ್ಲ objections file.
Statement of objection of R1 is filed. You want to file objections in this?
My lord, as on this day, my lord, a week, maybe on the same date, my lord. I will look into it.
And AGA 6 fund is granted 10 days time to file a statement of objection. Counsel for the petitioner is granted a week's time to comply with the office objection raised on the rejoinder filed by the petitioner. 39.2.
Lord, in this, they have filed an objections, my lord, for which we need to file a rejoinders, my lords.
The private respondent are 8. You have filed your statement of objection. The counsel for respondent number 8 seeks fund is granted a week's time to comply with the office objection raised on the statement of objection filed by respondent number 8. Counsel for the petitioner seeks for 2 weeks' time to file his rejoinder. Rejoinder, if any, statement of objections and rejoinder, if any, to be filed on or before 3rd July, released on 9th July.
The interim order may be extended.
Interim order, wherever granted, is extended till the next date of case.
39.3.
39.3 ಒಂದಿದೆ ಅಲ್ಲಪ್ಪ.
39.3 ಒಂದಿದೆ.
39.3.
Same hospital, where they are challenging a notice issued.
And AGA 6 fund is granted 10 days time to file a statement of objections.
Serial number 40 adjourned, 41.
Appear for respondent number 1, my lord.
Cooperative Bank versus IDBI Bank. And
My lord,
why
in
is
fact,
it
the
before
money
that?
which I received, my lord, 1 crore 37 lakh. Somebody, my lord, defaulted, my lord, their deposit the money in my account.
It is under the wrong notion, my lord, that lien has been created in respect of, as per the acknowledgement which has been received by the respondent number 2, my lord. As your lordship could be able to see in page number 16, my lord, at annexure A4. But while giving this information to the petitioner, my lord, one of the lien amount which has been amounting to 22 lakhs has not been included in the information, my lord. Subsequently, on the next day, in the email, the same amount has been included and it has been informed as per annexure A2, my lord. So this 22 lakhs, which my learned friend is appearing for the petitioner is seeking for that, my lord, that is also, the lien has been created as per the instruction given by the respondent number 2 only, my lord.
Where is the instruction of respondent number 2?
My lord, it is there with the bank, my lord. That acknowledgement number we have given it, my lord. Your lordship may kindly see it.
No, where the correspondence received by you? You must have received a
Uh,
correspondence from respondent number 2. Where that
Lordship, can we
correspondence?
have this on the next week, my lord? I'll file a memo along with all the details.
Counsel for respondent number 1 seeks for and is granted a week's time to place on record the correspondence received by respondent number 1 from respondent
But I'll
number
also
2.
place an affidavit. What had happened, my lord? This money I received, my lord, from the, my lord, borrower, he availed a loan from me. I nothing to do, my lord. I don't have any, my lord. I'm a,
If borrower gets proceeds of crime,
my lord,
you
my
can take
difficulty, my lord, I
benefit of
received
it.
the money pursuant
That
to
we
It
have
is
to
not his money to
urgent it
pay.
before the appropriate forum, my lord.
It is not his money to pay you.
my lord,
Somebody else's money which has to go back.
my lord, in fact, my lord, I'll place all those records, my lord.
You can proceed against the borrower.
Much,
Released on 25th.
Great.
much.
Serial number
ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ
42.
ಬಂದಿದ್ರೆ ಕ್ಲೀನ್ ಆಗತ್ತೆ ಅಂತಲ್ಲ.
Serial number 42.
For the respondent, my lord, it's with respect to defreezing of account, my lord. Your lordship may have it on Monday, my lord. I'll complete my instruction.
Where is the?
I'll place that on record, my lord. In fact, I've told them to give me the specific amount also, my lord, for which.
You have to place the
I'll
correspondence
place
on
that.
record.
Your lordship may have it on Monday.
That counsel for respondent seeks fund is granted 3 outstation.
Outstation.
Seeks fund is granted 3 days time to place on record the correspondence and orders received by respondent bank from the jurisdiction police authorities. Released on 22nd.
Obliged.
Serial number 43. Rakesh.
Lord, appearing for petitioner in this case, Lord. Lord, the direction, Lord, tender matter had filed appeal before the appellate authority. That appeal was not considered, my lord. That is the grievance, my lord, with which I had come before this honorable court. During the pendency of this petition, my lord, a hearing took place on 7th May. Lord, the appellate authority has called for some records and has also granted stay, my lord. With direction,
Infructuous.
no, with direction to dispose of the appeal, my lord.
Yes.
7th May, first hearing was.
Petitioner is before this court seeking for the following reason. The grievance of the petitioner was that the appeal which had been filed by the petitioner before the first respondent had not been taken up for consideration. During the pendency of the above matter, the first respondent has taken up the same said appeal for consideration, and the first hearing was held on 7th May 2026.
And then
And
no
the first respondent
7/5/26.
and first respondent
7/5/26.
7/5/26. And the first respondent has called for certain information and answers to certain queries raised by the first respondent, which is in the process of being given to the first respondent. Learned AGA submits that. When will the appeal be disposed?
Lord, your lordship may kindly fix 2 months.
2 months. And AGA submits that given 60 days time, the appeal will
Please, madam.
be disposed. The said submission answers the grievance of the petitioner, placing the said submission on record. Petition stands disposed.
Obliged.
Pending IA stands disposed.
44.
I'm a petitioner, madam. I'm challenging the annexure A, page 11, my lord. The association has completed a term, my lord. Thereafter, they elected a fresh executive committee. Now, the respondent 3 passed an order, the annexure A, my lord. Annexure B is the notice to the general body meeting. Annexure C is the newly elected general committee, madam, my lord. And the petitioner is elected as a president.
Now the respondent number 3 has passed an order, call for the new general body meeting and elect a new committee, my lord. Already since 1 year they are working as a president and new executive committee has been elected. And 2/4/2025, madam. New executive committee is elected. 2/4/2025, my lord. Annexure C, my lord. Annexure D, typed copy, page 19, my lord. ಈ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕಾರ್ಯಕಾರಿ ಸಮಿತಿ ಸದಸ್ಯರಾದ ಸೋನ್ಸು ಕೊಲ್ಪಪೇಟೆ ಸೂಚಿಸಿ ಟಿವಿ ಮುನಿಯಪ್ಪ ಅನುಮೋದಿಸಿದರು. ಈ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಸಂಘದ ಕಾರ್ಯಕಾರಿ ಸಮಿತಿ ಸದಸ್ಯರಾದ ಮುನಿಯಪ್ಪ ಕೋಲಾರನ ಅಧ್ಯಕ್ಷರಾಗಿ ಸೋಮಶೇಖರ್ ಗೌಡರನ್ನು ಸೂಚಿಸಿದರು. ಸಭೆಯಲ್ಲಿದ್ದ ಅಪ್ಪಯ್ಯ ಗೌಡರು ಅನುಮೋದಿಸಿದರು. Since 1 year they are working as a president and executive committee as enforced, my lord. Now after.
Why, madam, why have you asked them to? Copy is not, sir. Oh, service charge.
ಅದು classification wrong ಆಗಿ ಅವ್ರ ಮುಂದೆ ಪೋಸ್ಟ್ ಆಗಿದೆ.
AGA accepts notice for respond number
1 to 3.
1 to 3. Notice to respond number 3 is deferred for now. Learned AGA is direct secure instruction. Counsel for the petition furnish 2 sets of the petition along with annexures on learned AGA, who seeks for a week's time to secure instruction, make a submission as regard the reasons for issuance of the inquiry notice at annexure A dated 28/4/26. When the submission of the learned counsel for the petitioner is that elections to the society were held on
2/4, new executive committee is 2/4/25.
25 and the executive committee is discharging its function for more than a year. Released on 25th.
Meanwhile, stay the annexure A, my lord.
Agilla.
Because since 1 year they are working, my lord.
Let us find out what it is.
Till then, my lord.
25th.
B group matters, serial number 45.
For petitioner.
Petitioner is a contractor. He had completed.
For appearing for whom, madam?
R4, your lordship, CB.
R4 is C.
Deshpande, Venkatramana. Yaar against order.
Please, madam, the earlier.
1 to 3 na 4.
Yaru?
R4.
R4 is CBI. They are formal parties for this
Formal
petition.
party.
Only Railways Union of Madhukar is.
Paso.
Please, madam.
46. Dhananjaya.
Blood appear for the petitioner.
Ramesh. Paso.
47. Mahendra BS.
In this case, appearing for petitioner, my lordship. Lordship, in this case,
Respond number 4, Kumara KG.
we are filing joint memo, my lordship. The advocate and party in person, both our signature has been done.
Body.
In this case, both respondent has borrowed loan from the petitioner, my lordship. Later on, she filed complaint against us. And the compromise memorandum of we have filed and joint memo to a matter has been said, my lordship. Regularly, she will agree to pay the EMI on the loan account has been regularized, my lordship.
Petitioner is before this court seeking for the following leaves. A joint memo has been filed, signed by the petitioner, counsel for the petitioner, representative of the respond number 4, and the counsel for respond number 4, which reads as under. Said joint memo is taken on record. The petition is disposed in terms of the contents of the joint memo.
Grateful, my lordship.
Serial number 48.
Grateful.
My lords, I appear only for the respondent number 5 in this matter, my lords.
Only for 5, not for 4.
Please. No, my lords. I think there's a different
Who is-
nomination in this.
Who is 4?
4 is my lord.
Who will appear for 4?
Just
4 is Union of India.
5 where?
I appear for 5, my lords. Council of Architect.
4 is Union of India, my lord.
Then who will appear for respond number 4, Union of India?
I'll take notice, my lord.
He'll already idella nim 4 and 5 alli.
Adu bari, I had only a nomination for 5.
CGST for R4 and 5.
History of education.
I'll take notice, my lord. I'll accept.
My lord, the notice stage is already gone. This is actually supposed to be a B group, my lord. I mean, notice has been issued long time back.
Long time back.
My lord, the issue with this matter is about, I'm an architect, my lord. Under the Architects Act, the state has to nominate a member to the council under 3(3)(f) of Architecture Acts, my lord.
The
But
order on 2/12/25. R3 and R6 have filed their objections.
state also has filed objection, my lord.
R3 and R6 served by hand summons. Yaru ilwalla?
We have filed objection.
R3 ನೀವು.
ಹೌದು.
R6 ಅಂತಾನು ಇದೆ.
ಅಲ್ಲ R6.
That is a nominee, my lord. The R6 is a
nominated
K. K. Uday is a nominee, man.
ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ objections R6.
ಇಲ್ಲ R6 is not represented.
ಅವರು ಪ್ರೆಸೆಂಟೇ ಮಾಡಿಲ್ಲ, my lord.
ಇಲ್ಲಿ
ಅದು ಹ್ಯಾಂಡ್ ಸಮನ್ ಸರ್ವ್ ಮಾಡಿದ, my lord.
Title SOB filed by R3 and R6 is placed below ಅಂತಿದೆ. Yes, ಕೊಡಿ petition ಕೊಡಿ. What is the relief you are asking for?
My lord, I'm challenging the notification of the state and
State government.
yes, my lord, because I have an order in. I applied for an application in 2021, my lord, to be nominated to the council, and then there were no criteria and there was no procedure followed, and then this honorable court has issued an order saying that in the next 2024 beginning, when the next term is over, you should consider the applications on application, my lord. But other than that, what this honorable court said is come up with a criteria for the central government and also state government, my lord. On central government has come up with a criteria as well as the state. And according to central government criteria, the petitioner is eligible to be nominated, my lord. But the state, what they did, they come up with a criteria which points out to the only one person in the state, my lord, who's working for the state department, not for the general public, because there are more than 10,000 architects in Karnataka who are eligible to be nominated, my lord. So that itself is a contempt, my lord, because intentionally they come up with a criteria which eliminates the petitioner from the filing the application, my lord. Kindly see the objection copy filed by the state, my lord. On the last page, they have listed out the R1. They have listed the criteria, my lord. If we go through this criteria, it applies to one.
Where is the criteria?
My lord, it is R1, my lord, in the objection copy filed by the state.
ನೀವೇ ಬರ್ದಿದ್ದೀರಾ 3 and 6 ಅಂತ ಬರ್ದಿದ್ದೀರಾ. By state for respondent number 3 and 6. So you have appeared for 6 also. The 6 is your nominee.
The 6 by name it is there, my lord. We cannot accept notice.
That's what
But
your
though he is our
objection
nominee,
states.
my lord, if it is an authority, then we will accept notice. Maybe wrong. Notice has to go to him. But however, my lord, the
Notice has been served, he has not appeared.
Yeah, hand summons has been served.
Served to be nominated.
My lord, if you look at the notification of criteria, the officer must have completed minimum 10 years. This condition is okay. But the officer at the time of nomination should be working in a group A post or shall hold the designation of chief architect or deputy chief architect. Deputy architect, man, this related to state, my lord. What about the public in general? And then the third one is the officer must have a registration that is common, my lord. And according the respondent number 6, who is nominated, he is in violation of this own criteria, my lord, because he is already retired, my lord. The second criteria does not apply to him also, my lord.
My lord, attaining superannuation does not give him a right. Now, my lord, the first criteria applies to the appointee of the state. It says the officer must have completed 10 years, minimum 10 years.
So why would the state want to, how will the state choose among 10,000 architects who is to be appointed?
No, my lord, see, there is a nomination, it is a nomination by the state. That means there should be advertisement in public notification to be filed for the application for the nomination, my lord. Because eligible architects are all applied to this. But once I did in 21, but since from the 72 Act is formed, there was no criteria formed. They're just nominating anybody.
Come under 33A.
33F,
Five
my lord.
architects as a processing recognized qualification elected by the Indian Institute of Architects from among its
Why not
members.
33F, not 33A? It
You
says,
can come under 33A. 33F is the state's prerogative.
no, an architect is nominated from the state government, my lords, in the Karnataka state government.
That state.
Huh?
By that state, the state
Not the
policy
state government, by the state. That doesn't mean that the government employee, my lord.
is the state's public policy.
State's policy.
How do you get a vested
My lord,
right
that-
that
Yes, no
you
vested
will have to be nominated by the state?
My lord, not saying nomination, consider the application, not the nomination. Consider nomination should be made on the merits, my lord.
An architect from each state nominated by government of that state. It is left to the state who they want to nominate.
My lord, this honorable court has said, come up with a criteria to be nominated. And the
Come up
central,
with this criteria.
central government has come up with a criteria, my lord. In that they have called, they said that anybody, who are an architect can be nominated.
This,
But this is a very specific criteria that saying that the state come up with saying on the state
represent
employees.
the state. He'll represent, each of the state will be represented by one architect.
State government, state means Karnataka state, my lord, not state
No.
government.
Karnataka will nominate one.
Yes, yes.
Tamil Nadu will nominate
Yes,
one.
yes, my
Kerala
lord.
will nominate
Yes,
one.
my lord.
Maharashtra will nominate.
Yes, my lord.
Everybody will nominate.
Yes, my lord.
The state will nominate its officer.
And he is representing that state.
He'll represent the state. It is the state's interest which has to be taken care of in the
Before
council.
the council.
My lord, they are also allowed to be nominated, but consider the other people who are architects in
Private
general.
person, you cannot be part of it. You're a state nominee. How
My
will
lord,
you
just
consent?
read one more time. I'll read the 33F. It
Yes.
says an architect from each state. Each state means it is Karnataka state, my lord. Nominated by the government of that state. It doesn't mean that state government, my lord. Nominate from each state. That means all the architects are eligible to be nominated.
That is what you say, but that is not how we read it.
My lord, clearly says.
If it is a representative of the state, it is for the state to decide who it is going to nominate. The state may choose to nominate you. It's not the thing. You cannot find fault with their policy. It is state discretion. Because this person is going to represent the state.
My lord, in the order which I got in 2021, it clearly says that the petitioner
There are no,
application
at
should
that
be
time there
considered.
was no regulations.
No criteria, my
No
lord.
criteria.
Yes, my
How
lord.
do they come up with this criteria?
My lord, after that,
How is this criteria? You'll have to show us whether it's arbitrary, manifestly arbitrary, unconstitutional. You'll have to show us. We don't explicitly see that to be arbitrary.
My lord, I have challenged the criteria also in WP 1150, my lord. During the pendency of that writ petition, they are not during the writ
You
pending
have challenged this annexure R1.
R1, my lord. In other writ petition, I have challenged the notification itself, my lord. Can be heard. It can be heard connected, my lord.
That is pending.
Pending, my lord.
Connect with WP number.
1150-2023, my lord.
Objections have been filed in that, Jafar? In that other petition, objections?
I don't have the information.
My lord, objections not filed, but this honorable court said file the rejoinder to the notification. I have filed the rejoinder.
Objections are not filed. What rejoinder?
No, objections are filed, but I was asked to
Are
file the
filed in
rejoinder.
that matter
Yes, yes, my
by the
lord.
state.
Yes, my lord.
Connect with so and so. Find out if it's not filed, file it.
Yes.
Relist on 3rd July.
My lord, all these years, they are nominating anybody and everybody, my lord. Now, in the sense, anybody
their
is architect.
discretion.
And then when the state asked them to come up with the criteria, they eliminated all the architects, including me. Even I have an order with order this saying that application should be considered. We are not asking for the nomination, we're asking for the consideration of application. So when you look at I have a master's post.
You want only consideration.
No, I mean in the sense on the merit selection should be made.
Tried and rejected. What is there?
His application
That's
was
what they have filed in the objections, my lord.
His application was filed, my lord, and only his application was filed. Now Mr. Uday is selected in that all the three applicants.
Have you rejected
my
this application?
one more thing about this.
Virtue of the appointment of the other person, the three applications that have come, automatically he is not entered.
My lord, one more thing is K. Uday who is nominated, he is not eligible according to the criteria, my lord. Because number 2 says the officer at the time of nomination should be employed. He is retired in 2016, my lord.
Does not say so.
No, no, that,
Anyway, we are taking both of them together on third.
Yes.
49. Vidyasagara.
My lord, passport renewal, my lordship, a trial court has permitted me to get renewed the passport, my lord.
Who appears
My lord,
for the center? Yes, madam.
My lords, I'll take notice.
my lord, it is already
Notice
notice
is
taken, my
Shanti
lord,
Bhushan is already
already
taken.
I
everything
don't know, I
over.
don't have the nomination, I don't
You
have
can
the
appear
file, my
now,
lords.
that's all.
My lord, I am regularly appearing from 2023 before the court, my lordship. I am working in Dubai, my lord. The permission was given to work in Dubai, my lord.
Yes, madam.
And there is
You want to go back and work there?
I am regularly working there only, my lordship.
The trial is going on here. How can you go
Every
and
day
work
I
there?
am coming, my lordship. Whenever date is there, I am coming back and attending regularly. There is no,
Where is the order sheet?
my lord. Order sheet. After considering the same, the court has permitted me to
Where
get
is the
it.
order sheet indicating that you appeared on all the dates?
My lord, part of the order sheet, it is there, my annexed J, my
Where is the
lord.
order sheet on record?
Annexed J, my lord, page
Also,
number
for the
155.
petitioner submit that the petitioner has been appearing before the trial court without default on all the dates
All the dates, my lord.
and his travel
But
to Dubai
considering the same, only trial court has permitted
not
me.
affect the trial in the matter. He is directed to place on record the entire order sheet of the said matter. Ms. Reshma Tamaya accepts notice for respondent.
My lord, it is
Registry is
produced.
directed to print her name as such and delete the name of Sri Shanti Bhushan as that appearing for respondent number 1.
Please, my lord.
Relist on, when will you produce it?
My lord, next week, my lord.
ಯಾವತ್ತು ಹೇಳಿ ಡೇಟು?
Monday, my lord.
22nd ಕೊಡ್ತೀರಾ? 22nd.
Please.
Serial number 50.
I appear for petitioner in this matter, please, my lord.
Yes.
The petitioner has filed this petition to remove his name from the rowdy list from the respondent number 4 in police station, please, my lord. They have filed a memo along with stating that number of cases against the person and hakidare on the last occasion. None of the cases are pending, please, my lord. It's all old cases. That is what we are also stating, that for more than 15 years, there is no cases pending against the petitioner. In the name of rowdy sheeter, he was regularly calling. Lordship may kindly see on the last occasion when the prosecution filed up his memo. In page number 3, they have stated in the last page, on 18/8/25, our rowdy list ಅನ್ನ ಮತ್ತೆ renew ಮಾಡಿದಾರಂತೆ. After filing this petition, we have filed this petition on 4/8/25. Even prior to that, we have issued a legal notice on 22/7/23. Prior to that,
96, 97, 98,
yes, my
2003.
lord, that's all pending. Old cases is all acquitted, and no cases are pending presently. And in spite of that, they are regularly calling this person to station. He is running an auto from morning to evening. We have been meeting him to sit in the station.
Mr. Narendra Babu, we know
Please,
you
my
are
lord.
prepared. Please give time to the AGA also to make his submission.
They have filed.
We'll consider, my lord.
In consider, delete. To 97, 98 ಇಟ್ಕೊಂಡು ಇವಾಗ ಓಪನ್ ಮಾಡಿದ್ರೆ ಹೆಂಗೆ? Petitioner is before this court seeking for the following. You will never allow anybody to reform them. The grievance of the petitioner is that on the basis of crimes which have been registered against the petitioner, the grievance of the petitioner is that a rowdy sheet has been opened in respect of the petitioner by the respondent police when there are no proceedings which are pending against the petitioner, despite the request made by the petitioner to delete the name of the petitioner from the rowdy list. It's not been done. And it's that background that the aforesaid reliefs have been sought for. The learned AGA was called upon to place on record the proceedings which are pending, filed and pending or disposed against the petitioner. A memo has been filed on 10/2/26, enclosing a list of 20 matters. Perusal of the said list indicates that these are proceedings which had been initiated in the year 1995, 96, 97, 98, and some of them a little while later in 2005 and 2008, etc. Angbada. a peril of the same indicate that the earliest matters were of the year 95, 96. However, what is important to be noticed is that most of those proceedings have ended in the acquittal of the petitioner, though a couple of them have ended in the petitioner being sentenced, convicted and sentenced. The fact, however, remains that out of the said 20 matters, no proceeding is pending as on today. All the proceedings have been disposed, the last of the disposal being in the year 2014. Subsequent to, apart from these 20 proceedings, there are no other proceedings which have been initiated against the petitioner. And subsequent to 2014, there is no proceeding pending against the petitioner. Such being the case, the object of criminal jurisprudence being the reform of criminals or alleged criminals, it is but required that on acquittal in proceedings and thereafter, for a reasonable period of time, there being no other proceedings initiated against a citizen of the country, the rowdy sheet, his name would have to be deleted from the rowdy sheet. The continuance of the name of a citizen in the rowdy sheet goes contrary to the reformist principle and will not permit a citizen to reform himself. In the present matter, the last of the complaints have been filed against the petitioner in the year 2012. The last order being passed in the year 2014. There is no other proceedings against the petitioner from that date, in requiring the rowdy sheet to be kept alive in respect of the petitioner. As such, this court passes the following order. Writ petitions allowed. The respondents are directed to remove the name of the petitioner from the rowdy list within a period of 4 weeks from the date of receipt of copy of this order.
Machal.
51. Venkatesh P. Dalwai.
Yes, Mr. Dalwai.
11/11/25. Lord, your lordships had directed the respondent to place on record within what time my lord's inquiry can be completed. That is the relief I had sought in the prayer.
7/11.
11/11/25, my lord.
As regards status of inquiry and time that it may take.
Look at.
Lord, in January 26, my lord, the complainant was asked to give his response to the comments which we have received from about 20 DGOs against whom the complaint is filed. He has given now, not some reasonable time, we'll.
ಯಾವಾಗ ಹೇಳಿ?
ಯಾಕೆಂದ್ರೆ ಇವ್ರು ಕೊಟ್ಟಿರೋ ಮೆಟೀರಿಯಲ್ ಅಲ್ಲಿ ವಿ ಮೇ ದಿ
ನಿಮ್ಗೆ ಎಷ್ಟು ಟೈಮ್ ಬೇಕಪ್ಪ? ನಿಮ್ ನಾಳೆ ಮಾಡು ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ.
ಅಲ್ಲ, ದಿ ಆನರಬಲ್ ಲೋಕಾಯುಕ್ತ ಮೇ choose to issue a 12/1/12/3 report or may choose to close the complaint or it could further investigation.
Your prerogative.
Yes, further investigation also could be possible. That's why.
In reasonable time, it's pending for long.
Yeah,
time.
3 months, your lordship.
3 months. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner, when he had approached this court, was that the complaint which had been filed by the petitioner before the Honorable Lokayukta had not been acted upon and the investigation not completed. It's in that background that on 11/11/25, this court had called upon the counsel for respondent number 1 to inquire and make a submission as to by when the inquiry would be completed. Today, the counsel for respondent number 1 submit that the inquiry will be completed given 3 months time.
Inquiry Allah. He has filed complaint. It is still in a initial stage. 12/3 report or 12/1 report or not closure.
ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
But we are considering the complaint in the light of the replies received from the DGOs.
The complaint is being considered on the basis of the replies received from the DGO.
Notices.
Notices and DGO ಹೇಳಕ್ಕಾಗಲ್ಲ ಇವಾಗ. Notices
and
the response of the
complainant
petitioner, and necessary orders would be passed within 3 months time. Necessary action taken within 3 months time. Further action taken in 3 months time. The said submission answers the grievance of the petitioner. Placing the said submission on record, petition stands disposed.
52. Raghu TJ.
Appear for petitioner.
The petitioner is preferring this petition challenging the order passed by 26/2055 passed by the first respondent in case number senior citizen case 26 of 2024-25 allowing the petition filed by respondent number 2 under Senior Citizen Welfare Maintenance Act, Your Honor. In this case regarding issue notice to respondent number 2 and also ready to compromise the matter in the out of settlement, Your Honor. Petitioner respondent number 2 both are present before this honorable court, Your Honor.
Where are they present? Notice hogilla.
Deferred.
Father and son.
Where are they?
Deepak. Deepak.
ಮೂರ್ ಸತಿ ಕರಿಬೇಡಿ. ಮೂರ್ ಸತಿ ಕರೆದ್ರೆ ಮೂರ್ ಸತಿ ಕರಿ ಕೊಡುದು, ಮೂರ್ ಸತಿ ಕರೆದ್ರೆ ಯಾರನ್ನ ಕರೀತಾರೆ ಗೊತ್ತಾ? ಸೆಷನ್ಸ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. Where is the father?
ನಿಮ್ಮ ಫಾದರ್ ಇಲ್ಲ ಇಲ್ಲ, ಕರ್ಕೊಂಬನ್ನಿ ಕಡೆ, ಕರ್ಕೊಂಬನ್ರಿ.
He has to appear through a counsel and to file a joint memo. Terms of compromise you file, will record it.
Yes, yes. Kindly pass over.
ಇವತ್ತೇ ಫೈಲ್ ಮಾಡ್ತೀರಾ?
ಇವತ್ತೇ ಮಾಡ್ತೀವಿ. Kindly pass.
Serial number 53.
For the petitioner, my lord.
Yes.
My lord, this matter is pertaining to defreezing of the bank account, my lord. Defreezing of the bank account of the petitioner. Where the communications received by the bank was from interstate police stations, my lord.
Who is the bank? Kotak Mahindra.
Kotak Mahindra, my lord.
Yarama Kotak Mahindra. If Francis Xavier is directed to accept notice for respondent number 1, counsel for the petition serve 2 sets of the petition along with annexures on said counsel. Sri Francis Xavier is directed to secure and place on record the orders and communications received by the jurisdiction police in respect of the bank account of the petitioner. Released on 22nd. 20.
My lord.
22nd.
My lord, accordingly, interim order.
It will dispose of finally depending on the order that they have received. If it is for full account freezing, your remedy will be different. That is what
It was
we
a
are
full
trying to
account,
see what-
full bank account was freezed, my lord.
Let us see what the correspondence is.
54. Sriram Nayak.
For the petitioner in this case, Your Lords, there's a connected matter. Your Lords may connect this
What
matter
is
with
this matter about?
It's with reference to making.
Defreezing or
No, no, it's,
FSI?
to send the account to CBI, Your Lords, for inquiry.
No, this is 54, my lord. This is regarding treating the account as a fraud. Whether the procedure of RBI has been followed. That they have challenged here. Because
They have not issued a notice.
Party has committed a fraud and that forensic laboratory report was issued and then notice was issued to him to say that whether it has committed a fraud. There is RBI guidelines here that before treating as a fraud, notice has to be issued. And 2 notices sent and they have not come. Then the competent authority decided the matter as a fraud and reported to the competent authority. Now, against this treating as a fraud, this writ petition has been filed.
Challenging that order.
Challenging that order. Whether that.
What are the other writ petitions?
The other writ petition is similarly challenged with this bank itself by one of the other directors. So this matter may be connected.
Connect with so and so.
And listed on 3rd of July, Your Lords.
3rd July.
Much obliged.
55. Shri Rama.
55 with both the police stations are local Karnataka police station. One is Ballari. But then disputed amount the bank has to state.
Yaru bank yana?
Karur Vaishya Bank anta ಹೇಳ್ತಾರೆ.
55. Assistant Commissioner AG ಅಂತಿದೆ. 55.
R1 is Karur Vaishya Bank.
ನಮ್ಮ ಕಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಅಂತಿದೆ. 55 ತಾನೆ?
The next matter.
55 my lord.
57 ಅಲ್ಲಿ Karur Vaishya Bank.
Sorry my lord, I
55. Mr. Srirama. Bank guarantee is challenged for the release. None appears for the petitioner. If none were to appear, by next date of hearing, dismissal for non-prosecution, released on 30th June under the caption dismissal for non-prosecution.
Serial number 56, MB Prabhakar.
Petitions.
Yes, Mr. Prabhakar.
Mr. Petitioner, the owners of the redeemed Sagu lands granted by the government of during the year 1877, my lord, precisely
Yes, madam.
28/6/1877.
Waived for now and for the future.
Yes, my lord.
Apology, my lord, the objections are not filed. My lord, this government order, my
74
lord, if
order.
my lords may kindly see, the first clause, my lord, if the tenure of any land is shown as redeemed in the Jamabandi records, right from the beginning of 1901, further verification with regard to the payment of timber value, etc., need not be initiated upon, and recommendations from the Mafi Pass
Insisted
may be
upon and
issued.
recommendation for?
The first clause, my lord.
Yes, may be issued.
Please, my lord. Second, my lord, in case where the owner claims that if the tree value has been paid for subsequent to 1901, the revenue officer should verify the payment from the treasury records in the absence of the evidence forthcoming from the party and recommended issue of Mafi Pass. Now, my lord, the present in the instant case, my lord,
It goes.
it is redeemed
yeah.
between 1904 to 1916, my lord. As such, my lord, if my lords may kindly peruse their prayer, it is for mandamus. Let them produce the document, my lord, evidencing that they have paid the timber value.
How, when was the redemption done? Mr. Prabhakar,
Yes, my lord.
when did you redeem?
My lord, lords may kindly turn to page 80, where they themselves admit all these redeemed Sagu, page 80, 81, and 82. They themselves admit it's a redeemed Sagu Jaga. Redeemed means the payment has been done.
ನಿಮ್ಮ ಪ್ರಕಾರ redeem ಯಾವಾಗ ಆಯ್ತು ಅಂತ?
My lord,
That procedure as per this notification 74.
my lord, Annexure B grant itself says, but the page number
So prior to
26, typed copy at 30,
this is 1877.
1877. But all the, right from, I have produced the Jamabandi extracts from 1912 to 1918 and thereafter.
They'll
entire
consider this
thing is
in
the-
terms of this.
My lord, this court has held, my lord, I don't know the notification what my land friend is relying upon, but I would like to place two judgments of this.
Madam has no she says allow the petition and fix the time frame and they'll pass orders in terms of this notification.
My lord, I'll place these two.
ಬೇಕಾಗಿಲ್ಲಪ್ಪ ಏನಕ್ಕೆ ಬೇಕು
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಸಿಮಿಲರ್
ವೇಸ್ಟ್ ಮಾಡಬೇಡಿ. ನಿಮ್ಗೆ ಯಾವಾಗ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಯೂಸ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ಯೂಸ್ ಮಾಡಿ. Petitioner is before this court seeking for the following leaves. The claim of the petitioner claims to be the owner of the land in survey number 114/123/789, 115, 116, 117/1, 73/1, 74, 75, 76, 77, 78 of Harur village, Somarpet Taluk, Kodagu district, measuring 113.69 acres. Para 1 inna jasti ಇದೆ. Survey numbers not good. And so on so. His submission is that the aforesaid land was granted as Paisari land to the predecessors, version of the grantee being Mr. Thomas Greenhill and Mr. Charles Bounton Spooner on 28/6/1877. His submission is the said land or Paradina redeemed land as regards
Not
which
Paradina, my lord. Redeemed Sagu land.
Paradina
There is a
tenure
difference
ಅಂತ
in Paradina
ಬರ್ದಿದ್ದಾರೆ.
land and Sagu land.
Para 2 ಅಲ್ಲಿ Paradina ಅಂತ ಬರ್ದಿದ್ದೀರಾ?
My lord, page 10, my lord, page 10, para 2, at the bottom, This day they have been recorded and shown
Except
as redeemed
the
sagu.
contention of the petitioner is that except for survey number 76, all other lands are redeemed sagu land,
Yes, ma'am.
whereas survey number 76 is Paradina tenure land.
Yes, ma'am.
And as such, insofar as redeemed sagu land, there is no requirement of any permission for felling of the tree, etc. The submission, the application which had been submitted by the petitioner on 7/9/21 at Annexure A has not been considered, and it's that background, the petitioner is before this court seeking for the aforesaid relief. Then AG on inquiry submits that it is the, what is this, madam?
This is the government order, my lord.
A government order dated 31st May 1974, which would apply to any such application. And the application of the petitioner would be considered in respect in view of the said government order and necessary orders passed within a period of
My lord.
4 weeks.
30 days from the date of receipt of a copy.
My lord, page 77, they have asked me to produce the challenge and receipt of the 1877. That's not permissible, my lord. This is this quota. That's why, my lord, I wanted to place this.
Clause
judgment
1
before-
of the notification, government order will apply to you. They have to issue it because it's prior to 1901.
My lord, that has been clarified by this Honorable Court, even by the division bench also.
Prabhakar, you are only asking for mandamus. If they reject, you can raise all these issues. Not at a time of consideration.
No, once I had come before this court directed them to do that. But they have not done that, and again this kind of notice has
Filed
been
a
issued.
contempt at that time.
No,
Your
that,
relief you are seeking for is a
that
mandamus.
opinion by the fourth respondent, my lord, given to the third respondent. It is not given to me. By virtue of that, I will not be able to cut my trees.
Within a period of 30 days from the date of receipt, so on.
But let them consider this judgment also, my lord. I will produce that judgment.
Said grievance. The said submission answers the grievance of the petitioner. Placing the said submission, petition stands dismissed. 30 days ಅಲ್ಲಿ ಈ ಸತಿ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ contempt ಹಾಕಿ. ನೀವು 2 ವರ್ಷ ಬಂದ್ರೆ ಅದು time bar ಆಗುತ್ತೆ.
Liberty may be given to produce this judgment also.
Liberty is reserved to the petitioner to place all such documents that the petitioner wishes to rely upon before the respondents.
Obliged.
57.
Appearing for respondent, my lord.
Yes.
Account has been depressed, hence this repetition becomes infructuous.
57.
May I make one submission, my lord? They have marked lien on certain amount. My lord, may I draw your lordship's attention to one particular document. Lordship may kindly take, my lord, page number 16. Page number 16.
Defreeze ಆಗಿದೆ ಅಂತ ಇದ್ದಾರೆ.
But they have marked lien, my lord.
Have you marked the lien?
We will find it out, my lord. We will find it out and get back.
Then you should make a full submission. Don't make partial submission.
So we have received the instruction that it has been defreezed, but lien part we have not got any confirmation from the bank side.
Also get the instructions.
58.
Obliged.
If there is no lien and no freezing, then it is infructuous. Otherwise, it is not.
58, my lord, is outside the state.
58 is outside.
Outside state, there are two issues. 10/2/2026, there was an abnormal transaction. They have not produced the records. If they produce the records.
Why have you frozen the entire account?
Entire account. There is a lien mark for 19,401 based on this notice. Apart from it, there was an abnormal pattern of transaction. We had sent him a mail that has not been produced. We have asked him to produce documents. Once he produced, my lords, the bank will take decision.
I have produced the entire bank statement before, my lords, and copy has
They
been
are
served.
asking you an explanation about the transaction,
Lord, I run my
not the
pharma
transaction. They're asking explanation. Can we get an explanation in the statement?
No, my lord.
If
What
that
the
has been produced,
explanation?
my lords, we have sent him a mail that has not been produced.
I will produce, my lord. I run a pharma company, my lord. I received from my clients.
Whatever it is,
I will
suspicious
produce.
is why they are
my
under duty to market if there's suspicious
Please,
transaction.
my lord.
So ಯಾವಾಗ ಇದು ಮಾಡ್ತೀರಾ?
Your lordship, other matters, my lord, are posted on 22. I will produce the same, my lord, on 22.
No, you have to give it to them,
Bank.
not to us. The bank.
Then they'll decide and they'll issue.
We're
an
not
endorsement.
going to decide on that. They have to decide. When are you going to give it to them?
One part is that, my lords. The second part is there's lien marked on 19,401.
19,000 will continue. The submission of learned counsel for respond number 1 is that there is, in terms of the information received by the instructions received by respond number 1, there's a lien of a sum of rupees 19,401.
401, page number 27.
401 on the account of the petitioner. However, the entire account was frozen by the respondent, by the bank on account of suspicious transaction having occurred in respect to said bank account, as regards which a notice had been issued to the petitioner. However, the petitioner has not replied thereto.
May I make one
Email.
Counsel for the petitioner submit that a reply with all explanation would be furnished within a period of
My lord, 2 weeks, my lord. My lord, let them mark clean, my lord, on 19,401.
That has already been
suspicious area. You clear that.
But I have to, my lord, even I make a reply to the bank. My lord, they will say, my lord, based on the police complaint, we have frozen the entire bank account.
19,000. Before you reply only, you ignore their mail.
My lord, I will reply.
And you come to assumption and presumption. When will you reply?
Or within 1 week, my lord.
Submit that you will reply to the said mail within 1 week from today, that is on or before 25th June.
Please, ma'am.
If such reply is received by the bank, Shri Jeevan Kumar Learned Counsel for respond number 1, submit that the reply would be considered necessary.
Within a week.
Taken
within a week.
a week thereafter. That is on or before 3rd July. Relist on 8th July.
Much.
59,
59, my lord, is outside the state.
Yes, Bank Yarama.
Francis Xavier.
Shri Francis Xavier is directed to accept notice for
This is
respond number
outstation,
1.
Lordship can have it on Monday.
If the lien is marked for a particular amount,
Fine.
then no need.
Then no need, my lord.
If it is debit frozen entire account, then we have that issue. Counsel for the petitioner to furnish 2 sets of the petition along with annexures on said counsel. Shri Francis Xavier is directed to place on record the instructions and or communication received from the jurisdiction police authorities by the bank by the next date of hearing, relist on 22nd.
60,
60, my lord, within the state, my lord.
HDFC,
Francis Xavier.
same Francis Xavier, same order 22nd.
Please, ma'am.
61,
Great.
Plus, the matter on hand pertains to cancellation of gift deeds, Milad. Executed. Senior Citizens Act. There was an interim order, Milots, payment of 20,000 rupees per month, which the respondent number 4 refused
to receive.
Milots, which prompted me to take demand drafts in the name of Registrar General and move it in the window. All such demand drafts are present before this court, Milots. First demand draft of rupees 60,000 was accepted.
You don't want the money, madam?
No, my lords. My lords, at the time, March, when the interim order was passed, granting 20,000 as maintenance, the council, who I believe was the caveator in the matter, there was some miscommunication. It was not communicated. They were told that 60,000 would be granted to the respondent number 4, and accordingly it was accepted. My instructions are, my lords, they didn't know that this 20,000 would be granted to them. Thereafter, my lords, I filed my wakalat in the matter, and it's come to my knowledge that demand drafts have been deposited in the court. If I may request your lordships to permit me to file necessary memo to have that money transferred to respondent number 4 insofar as that monthly maintenance.
If you are agreeable, then it
Yes,
will be
yes,
transferred.
absolutely, my lords.
If you are not agreeable to 20,000 rupees, then why should it be transferred?
No, my lords, I am agreeable.
Then you will continue to pay.
Please, my lords, for the demand drafts that are
Account
currently in the court, in fact, when inquired at the pending branch, it was suggested to me.
We'll have to direct the release.
Please,
So you are agreeable for 20,000 month on month.
please, my lords,
File a joint memo, file an affidavit.
please, please.
We'll do that.
File affidavits of all the parties
Please, my lord.
agreeing for this. And
No, Milords, I am pressing on the main matter as of now. The 20,000
if the
interim,
settlement is at 20,000, everything
No,
closes.
my lords. Actually, my lords,
they're not ready for
is not-
settlement, Milords.
What has happened is the crux of the matter is the petitioners are claiming there was a gift deed registered by respondent number 4. Respondent number 4 has 2 wives. The children of the first wife have filed the present petition. Their claim is that there was a registered gift deed, and the assistant commissioner, we executed. That is what is their claim. Respondent number 4 executed the registered gift deed. There was a transfer of the property. But my contention here is the contents of the gift deed. I am an illiterate. I am about 84 years old. I come from a rural background, and I have absolutely no idea what the contents of the gift deed are. once the registration took place, it came to my knowledge that attempts were made to change the entries in the records. And I filed a MC maintenance
But ready
application.
to argue on the merits of the matter?
Absolutely, my lords.
Ready to argue, my lords. Kindly have it on the 24th, please, my lords.
Ready having it on
24th, I'll tell, small impediment here is, my lords, the sub-registrar is to be brought on record.
One submission, my lords.
Relist on 24th.
One
Grateful,
submission, my
my lords.
lords. One small submission. If I may be permitted to submit this citation, my lords had
You
passed.
can submit everything on 24th, whatever you want to exchange between each other, do it by 24th, you argue on 24th.
Grateful.
Grateful, my lords.
Serial number 62, MG Shivanna.
Mr. Shivanna? Hemavati Nala, Yarappa.
Prashant Biyar.
Prashant BR for respond number 1 and 2. None appears for the, is directed to accept notice for respond number 1 and 2. Counsel for the petitions of 2 sets of the petition along with annexation on the said counsel. Relist on 13th July.
63. Vishwanatha KS.
Lord, petitioner name was entered in the rowdy sheet in the year of 2019, my lord, by registering a one case, my lord. That has been only one case, my lord, that has been acquitted. After that, my lord, since from 2019 till today also, my lord.
Do you open rowdy sheet for one case?
Lord, it's a 324 case, my lord.
Yavade case agli.
Only
one case. Habitual offender.
Yes, my lord.
Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that a rowdy sheet was opened in the name of the petitioner in the year 2019 on account of a complaint having been filed against the petitioner for an offence under section 324 of the IPC. The submission is also that the said proceedings resulted in acquittal of the petitioner on 1/9/25, and is pursuant thereto the petitioner had approached the respondents for removal of the name of the petitioner from the rowdy sheet, which has not been acted upon, though the representation was submitted on 6/3/26 and 7/3/26. It is in that background that the petitioner is before this court seeking for the opposite relief. A parallel of the papers indicates that a rowdy sheet was opened on 23/12/2019 as regards the in furtherance of registration of crime number 307 of 2019 for offences under section 324, 323, 504 and 506, which resulted in acquittal of the petitioner on 1/9/20, which ended in acquittal of the petitioner on 1/9/25. From the year 2019 till date, there is no other complaint or proceedings which have been initiated against the petitioner, except for that one complaint. The petitioner has not been involved in any other criminal activities. The said complaint also having ended in acquittal, I am the considered opinion that the rowdy sheet cannot continue against the petitioner. As such, this court passes the following order. Writ petitions allowed. Response are, a mandamus is issued. Respondents are directed to delete the name of the petitioner from the rowdy sheet opened in the 5th respondent police station within a period of 1 week from the date of receipt of a copy of this order.
Right.
64. Yes, Vishwajit.
Yes.
On the rep of the petitioner, I've challenged the notice issued under section 94 by respondent number 2. The FIR in relation to which the notice was issued concerns an offence that took place after the gold was pledged with me.
Yes.
The AG was
Here-
directed to seek instructions.
The parties are aged about 75 years, my lord. In the known person was visiting the house of the complainant. In the year 2025, they have noticed that the gold was
So they
stolen.
do not know when it was stolen.
Yeah, yes, my lord. In the year 2003, he has stolen from his friend. He has placed the ornaments in some in one finance. After that, in the year 2025, transferred. Almost 1 kg 700 gram.
Who is the person who has stolen?
The known person he is accused number 1 in the.
In what is the relationship between them?
Is a relative.
Relative.
Only relative.
My lord.
He's visiting the house of the complainant. He has stolen in the year from 2023, but it came to our knowledge in the year 2025. Later on, we lodged a complaint before the police station. After the investigation, we came to know that yes,
can
My
participate in
lord,
the investigation.
that may not be correct, my lord, because in the
You
FIR.
can raise all these, if you want to raise this as a, you are not the accused,
No, my lord, no, but if I
not
may just,
available
if I
for
may
you.
just
Only
make
to-
a small submission.
221
The
grams, my lord.
gold was alleged to have been stolen after it was even pledged with me. According to the FIR
Take over.
itself, the date of theft.
Yes, that will
is
have to be
after-
investigated. You can't decide.
If I may just
That
take
the
my lords through
magistrate
the
will
FIR.
decide.
My lord,
That
on the last
magistrate will
day,
decide.
on the last date of hearing, my lord had directed the learned AG to take instructions on.
That is what he
on
made his submission.
An
now.
alleged confession in the matter.
A known person is visiting. When he removed the gold from the house, they did not know. Whenever they came to know, they lodged a complaint. After investigation, these details are coming out. So
Obliged,
with
my lord,
further
but-
details, your investigation will also come out.
As per their own
And what
narration.
KYC you followed, what are the things that you did, that also you will have to furnish. You cannot retain their gold.
As per their own, the complainant's own narration, my lord.
Correct. They
The-
came to know about it on that day.
And as per them, it was, the gold was present with them even after it was pledged with me. So my submission is that the gold which was pledged with me is
That will be
separate.
investigated.
My lord may have the matter tomorrow.
No, no. What is there for that? Petitioner is before this court, seeking for the following reliefs.
My lord, counsel and record
The submission
will appear before
of the
my lord.
learned counsel for the petitioner on 5/6/26 was that the gold, as regards which the notice has been issued, was initially pledged with Messrs. Nishka Finance Private Limited at Mathikere branch on 5/4/25. But the FIR, which is lodged, indicated that the theft took place between August 25 and April 26. As such, a submission was made that the gold with the petitioner is not the gold subject matter of the FIR.
My lord may also
is being
record
investigated.
my lord may also record my submission that as per the FIR and the complaint
We're dealing
lodged
with it. That is what we are 25/4/26. On that basis, it is contended that the gold pledged with the petitioner is not subject matter of the FIR, and as such, the notice could not have been issued to the petitioner. In that background, Learned AGA was called upon to obtain instruction, make a submission. Today, Learned AGA submits that accused number 1 in the said FIR is a relative of the complainants. The complainants were not aware as to exactly when the theft took place. The gold has been removed from their house by the said relative accused number 1 from time to time without the knowledge of the complainants. And it is only after the complainants came to know of the removal that they had submitted, they had lodged a complaint giving the dates of removal as understood by them at that point of time. The facts are clear. Complaint which had been complained in FIR number
78 of
78 of
26
26 registered by the
Shivaji Nagar Police Station.
Shivaji Nagar Police Station, Pulikeshi Nagar Subdivision for offences under section 305 of the Bharati Nyaya Sanhita. The complainants alleging that their gold has been stolen by accused number 1. Accused number 1 along with the associates are alleged to have pledged the gold with Nishka Finance Private Limited, which was subsequently pledged with the petitioner. Such being the case, the actual aspects would have to be ascertained during the course of investigation to ascertain whether the gold is that belonging to the complainant and has been pledged with the petitioner, as also to ascertain the right of the petitioner in respect of the said gold. This court has dealt with the right of the pledgee of gold, more particularly gold finance companies in
IIFL.
IA so and so. The reasoning in the said decision would equally apply to the present case. Hence, this court passes the following order. The respondent, the petitioners are directed to cooperate with the respondent police and make, you have the copy?
My lord,
You have a copy of that order? The last directions which we have.
I don't have a copy of it currently.
Last directions copy ಮಾಡಿ ಅದು. Yes.
Number submission.
18 extended.
Petitioner is a law graduate, my lords. KSPC has called the enrollment of the petitioner only because of some discrepancy in the degree certificate. Though report submitted by the university, it is clear. My lords, my IIB certificate will expire on 21/6, my lords, before which I have to be enrolled.
19th.
Great.
Serve it on Gina track.
Sir.
4 DDs have been submitted by the counsel for the petitioner. It's currently standing in the name of the registrar. I may be permitted to take the money to the extent of those DDs, my lord.
We'll decide it on that day. They argued 24.
One submission was.
ಹೌದು ಯಾವುದು ಏನಿಲ್ಲ
ಮೇಡಮ್ ಲಾಸ್ಟ್ ಡಿಸ್ಮಿಸ್ ಅಲ್ವಾ ಅದು ಲಾಸ್ಟ್ ಡಿಸ್ಮಿಸ್ ಅಲ್ವಾ 64 ಮೇಡಮ್ ಇದರಲ್ಲಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಅಲ್ಲಿ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ನೋಡಿ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ಅವರು ಇಲ್ಲಿ ಇಲ್ಲ ಅಂತಿದೆ
ಮತ್ತೆ ಅಲ್ಲೇನು ಇದು ಮಾಡಲ್ಲ
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಮೇಡಮ್ ಅದಲ್ಲ ಮೇಡಮ್ 18 ಸಾರಿ 18 ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಬರ್ತಿದೆ 1 ವೀಕ್ ಬ್ಯಾಕ್ ನನ್ಗೆ ತೋರಿಸಿದ್ರು ಅವರು ಹಾಕಿಲ್ವಾ ಮೇಡಮ್ ಸರಿ ಮೇಡಮ್ ತರ್ಸ್ಕೋತೀನಿ ನಾನು
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ 7 ಕೇಸ್ ಕರೆದಾಗಿರ್ಲಿಲ್ವಾ ನೀವು ನೋಟಿಸ್ ಅದು 14/7 ಎಂಟ್ರಿ ಮಾಡಿರಲಿಲ್ಲ 76 ಇದೆ ಇದೆ ಹಂಗೆ ಮಾಡಿ ಡಿಸ್ಕ್ಲೋಸ್ಡ್ ಆಫ್ ಏನ ಗೊತ್ತಿಲ್ವೇ ಅವ್ರ ಹತ್ರನೂ ಇಲ್ಲ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಧಾರವಾಡದ ಒಂದ್ ಮ್ಯಾಟರ್ ಇದೆ ಅದಾದ್ಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಆಮೇಲೆ ಪಾಸ್ಟ್ ಅವರ್ಸ್ ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ ಸರ್ ಸರ್ 90
ಅಲ್ಲ ಸೀರಿಯಲ್ ನಂಬರ್ 9 ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್
ಮಧ್ಯಾಹ್ನ ಸರ್ ಅದು ಫಸ್ಟ್ ಧಾರವಾಡ ಬೆಂಚ್ ಮ್ಯಾಟ್ರು ಆಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್
ಅಲ್ಲ ಮೇಡಮ್ ಅದು ಏನಕ್ಕೆ ಅಂತ ಫರ್ದರ್ ಹೆಂಗ ರಿಸರ್ವ್ಡ್ ಇತ್ತಲ್ಲ ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ
ಏನೋ ಅದ್ರಲ್ಲಿ ಇವ್ರು ಇದಾರ ಸೂರಜ್ ಸಂಪತ್ ಇದಾರ ಏನೋ ಅವರೇ ಬಂದ್ ಅಲ್ಲಿ ಫೈಲ್ ಅಲ್ಲೆಲ್ಲ ಹುಡುಕ್ತಾ ಇದ್ರು
ಅಲ್ಲ ರಿಸರ್ವ್ಡ್ ಆಗಿತ್ತು ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ
ಅದೇ ರಿಸರ್ವ್ ಆಗಿತ್ತು ರಿಸರ್ವ್ ಫೆಬ್ರವರಿಲಿ ಅಲ್ವಾ 3 ತಿಂಗಳು ಆಗೋಯ್ತಲ್ಲ
ಅದಕ್ಕೆನಾ ಎಕ್ಸ್ಟೆನ್ಷನ್
ಮತ್ತೆ ಸೂರಜ್ ಯಾವ್ದೋ ಫೈಲ್ ಮಾಡಿಲ್ವಂತೆ ಪೇಪರ್ ಅಲ್ಲಿ ಹೇಳಿದಾರೆ ಬಂದ್ ಅವ್ರನ್ನೇ ಚೇಂಬರ್ ಅಲ್ಲಿ ಕರ್ಸಿ ಫೈಲ್ ಫುಲ್ ಹುಡುಕಿದ್ರು ಎಲ್ಲೂ ಸಿಕ್ಲಿಲ್ಲ ಅವ್ರು ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ ಹಾಕಿದ್ದ ಸೂರಜ್
ಸರಿ ಮೇಡಮ್
ಅವರು ಸೂರಜ್ ಸಂಪತ್ತು ಸರ್ ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಅಂದ್ರೆ ಅವರು ಡಿಕ್ಟೇಷನ್ ತಗೊಂಡಾಗ ಸಿಕ್ಲಿಲ್ಲ ಅಂತ
ಓಕೆ
ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರು ಅಲ್ಲ ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳ್ಬೇಕು ಯಾವ ಕೇಸು ನಿಮ್ಗೇನ್ ಬೇಕು ಅದನ್ನ ಹೇಳಿ ಕರೆಕ್ಟ್ ಆಗಿ